Good morning, everyone. Welcome to West Virginia University College of Law and to the West Virginia Law Review Symposium on Child Protection in the 21st Century. I'm Joyce McConnell. I'm the Dean here at WVU College of Law, and I am immensely proud and privileged to serve as the Dean of this wonderful law school and its wonderful law students, particularly, I'd like to say this morning, and the West Virginia Law Review students who are all here this morning. And if all of you would just stand for a moment so that everyone knows who you are. You may be seated. I want to thank the Law Review for their hard work and dedication to this critical issue. When we sat in my office in March to discuss the topic for this year's Law Review Symposium, there were very good ideas, two in particular, and it was very difficult for the students to choose which one to focus on. And I don't think that it was very hard once we talked about the significance of this issue internationally, nationally, and at the state level. They knew that this was the issue that needed to be addressed this year. I'm particularly pleased that they selected this issue because the law school has done a tremendous amount in this area to educate future lawyers for the state of West Virginia and for the nation, lawyers that will be particularly knowledgeable and sensitive to the issues that our most vulnerable, our children, confront daily in many of their lives. To be able to do what the law school has done, we have had tremendous support from the West Virginia Supreme Court of Appeals, and particularly from its court improvement program. And I'd like to say that one of our panelists today, Judge Johnson, has been the chair of that program for a long time, and Judge Johnson has made it possible for us to have a course at the law school focused exclusively on child protection law taught by adjunct Professor Catherine Munster, and thank you very much for being here. I understand there are two other members perhaps of the board here today of the Court Improvement Program. Teresa Lyons, Teresa's here, and Catherine, of course, and His Honor Judge Johnson. So thank you all very, very much for the support you've provided us. In addition, our Child Family Law Clinic provides support, guardian ad litem services, and representation to families and children in need. I think that that has made a huge difference in terms of our ability to educate our students and to turn out lawyers who will take care of children's interests in our court system. We're very proud of that clinic as well. And to Marjorie McDermott, who is the director of our overall clinical program, who for her entire career has dedicated her services and our clinical work to protecting families who are caught up in systems of domestic violence and in protecting children who are also in those systems. So our law school has a very, very long legacy of doing this. In particular, there's one person I actually just forgot to mention, but I see her standing in the back, Suzanne Weiss, who has been actually very instrumental in our child family clinic and particularly our medical legal partnership with the hospital. So I want to make sure, Suzanne, to recognize your work as well. So you can see I'm surrounded by wonderful, wonderful people who do very hard work and wonderful students who participate in these clinics and who really do serve the citizens of West Virginia in a way that makes me very proud. Today's Law Review Symposium is actually made possible in part by the Edward G. Donnelly Memorial Lecture Series, and I want to take a minute to tell you about this lecture series. These lectures are conducted annually under the direction of the faculty of West Virginia University College of Law, and this year by the Law Review itself. The purpose of these lectures is to bring to the university and to the College of Law distinguished members of the legal profession to talk to us about fields of current interest and development in the law. The Donnelly lectures and speakers make substantial and significant contributions to the growth of legal knowledge and illuminate the directions the law must take in fulfilling its function in society. And today we have the great privilege of hearing them discuss how we can play a role in protecting the most vulnerable. The Donnelly Memorial Lectures are made possible through income from a trust fund that's administered by the WVU Foundation. These lectures were established in the memory of Edward G. Donnelly by his wife, Eleanor T. Donnelly, and by Robert T. Donnelly, his son, now who are both deceased. Edward Donnelly had a distinguished career as a lawyer, engaged in active practice in Morgantown, West Virginia, from the date of his graduation from the College of Law in 1899 to his death on June 21, 1952. His life and career were marked by his outstanding contributions to law, including serving as a faculty member at the College of Law. It included incredible commitment to his church, to civic and financial affairs, and to the welfare and growth of West Virginia University and the College of Law. And I know were the Donnellys still with us, they would be very, very proud of the use of these funds today to help us think about how to protect our children. Thank you so very much for being here this morning.
Good, thank you, Dean McConnell. Good morning. For those of you who don't know me, my name is Amber Moore, and I'm the editor-in-chief of the West Virginia Law Review. So I'd like to welcome you to our symposium this morning, those of you who are here in our courtroom and those of you who are watching from home. One of the purposes of the Law Review is to promote positive change through academic discussion. We achieve this goal through publishing articles on important, relevant topics. However, our symposium is very special to us because it gives us an opportunity to engage our community, to educate and to inform ourselves and our neighbors of local, national, and global issues, to learn from experts such as those that are with us today, and to encourage dialogue about how we can foster these positive changes, beginning with our home communities and spreading outward. So we are here today to better understand child protection and what truly is in the best interests of the child. So before we begin, there are several people that I need to thank because this symposium would not have been possible without them. First, Dean McConnell, for your support and your encouragement and for helping us choose this topic. Assistant Dean Ann LaFaso, also for her support and her advice. Professors Gregory Bowman and Catherine Munster. This topic actually sprung from Catherine Munster's class that she taught this last spring. One of our symposium editors, Michael Bush, was in her class, and that was actually the root of this symposium. Margaret O'Bush, our events coordinator, who really is an amazing woman. Stenya McVicker, the Law Review editors, who I'm very honored to work with. Lewis and Keith, our tech support. And last but certainly not least, Kristen Brumley, James Jolly as well, because they have done so much work and created a beautiful program for us. Last, certainly but not least, Travis Brannon and Michael Bush, if you would stand for a moment wherever you are. Travis and Mike are our dynamic duo, and they are our article selection and symposium editors, and they have really put countless hours into helping plan today's symposium and really have made this happen. So thank you very much for all of your hard work. So without further ado, we are ready to begin, and would Professor Bowman please come to the podium as our facilitator.
Well, thank you, Amber. Thank you, Dean McConnell. Law Review Symposia. They are a highlight of our year at the WVU College of Law. So we are very pleased today to welcome all of our speakers. We look forward to their remarks on the important topic of child protection in the 21st century, and we look forward to learning from them. Now, before we begin, let me go over a few housekeeping matters. First, cell phones off or on silent, please. We have many, thank you, Your Honor. We have many speakers this morning. We have a tight schedule. So we need to stick to that schedule as closely as possible. There will be a quick 5-minute break after each speaker's remarks. And please do not enter or leave the room while one of our presenters is speaking. please wait until one of the breaks to enter or leave the room. Not only will that help us stay on schedule, it is also the polite thing to do. And while our state motto in West Virginia is indeed that mountaineers are always free, and perhaps free to do whatever they want, I think it is also true that good mountaineers are always courteous. And I think you can find that sentiment somewhere in our state constitution if you look closely enough, but I am admittedly not a textualist. One more item of housekeeping before we begin. There will be a reception outside in the law school lobby immediately following the symposium. We encourage all of you, we invite all of you to attend. You're all welcome to be there. Now, as for today's speakers hail from diverse areas, from the medical end of the spectrum, from academia, from national government, and from the state. Our first speaker, Dr. Claudia Gold, is our keynote speaker for this year's symposium. Dr. Gold is a pediatrician who specializes in the mental health needs of children and who seeks to address these needs through a preventive model. She runs the Early Childhood Social Emotional Health Program at Boston's Newton Wellesley Hospital, and she serves on the faculty of the Berkshire Psychoanalytic Institute and Brazelton Institute. Previously, she practiced general and behavioral pediatrics for more than 2 decades. She is a graduate of the University of Chicago and the University of Chicago Medical School, as well as of the University of Massachusetts Boston Infant Parent Postgraduate Certificate Program. She did her residency at the Montefiore Medical Center in the Bronx, New York, and her medical fellowship at the University of Massachusetts Medical Center. Dr. Gold is the author of the book, Keeping Your Child in Mind, Overcoming Defiance, Tantrums, and Other Everyday Behavioral Problems by Seeing the World Through Your Child's Eyes. Dr. Gold will be holding a book signing for this book in the law school lobby following this symposium. And I should also note that at this book signing, another author's leading book on the subject of childism will also be available for purchase. Dr. Gold is speaking today on confronting childism, how the field of infant mental health can inform the field of child protection. Dr. Gold.
Just going to have to ask you how to get my PowerPoint on here. Just click? All right. Great. Well, thank you so much for that introduction, and it's a real thrill for me to be here today. I really have to commend Mike Bush and the Law Review for being open-minded and perhaps also brave to invite a pediatrician to speak at a law school. And, you know, I think that while what we do every day in our work is quite different, there are some important points of commonality. I think that certainly we all are motivated in our work to give voice to children, and particularly children who are being hurt in some way. And I think the other thing we share in common is that we often are confronted, and certainly in my discussions at breakfast this morning confirmed this, by overwhelming and sometimes seemingly hopeless situations. And so I thought I would start by actually sharing, to give you an idea of what I do every day in my work, an example of one of those situations, which actually in a way motivated me to change my career path and lead me to actually be speaking with you about this subject. So as was mentioned, I practice general and behavioral pediatrics. I was working in a small town, a very busy practice. And this is a typical story, although I will change the details to protect privacy. So I did behavioral pediatrics, and I had on my schedule ADHD follow-up, which is typically a 20-minute visit, usually just to check in on a child's symptoms and to write a prescription for medication. So this was actually the first time I'd seen this child. It was an 8-year-old girl, and was referred. She had been evaluated by a psychiatrist, a child psychiatrist in a nearby town. However, it was felt that the family lived too far from that town, so that they would just come to see me to write the prescriptions instead. And when I reviewed the chart, this is what I learned about this child, is that she had actually, in the first year of life, experienced significant physical abuse at the hands of her biological mother. She had subsequently been in a number of different foster homes and had experienced sexual abuse. Then she went to live with her father, who was actually in prison, and she was now living with the father's girlfriend, who's the person who brought her to my office, and her two young children. So there was an expectation on the part of this caregiver, the part of my office, the part of the psychiatrist, the part of the school, that somehow in a 20-minute visit, and these visits are usually every 3 months, I was going to figure out why this kid was having behavior problems and adjust the dose of medication. And this was the only treatment this child and family was getting. So, and I had situations like this on a daily basis, which was, as you can imagine, rather horrifying to me. So what happened was my distress at that situation led me both to learn about the field of infant mental health as an alternative paradigm of care, and also led me to discover this notion of childism to explain what I was experiencing. So what I'm going to do today is, first of all, define childism. I'm going to talk about what childism looks like in the field of child protection. Then I'm going to introduce you a crash course in infant mental health as an antidote to childism. And lastly, I'm going to propose some ways in which the paradigm of infant mental health might be integrated into the field of child protection. So what is childism? Childism is a concept that was defined in this brilliant book, Confronting Prejudice Against Children. And this book came out in January of this year. And it's written by Elizabeth Young Bruhl, who was a psychoanalyst, political theorist, and biographer. And she tragically died suddenly about a month before the book was released. So not only was this a terrible situation on a personal level, but it deprived us of the opportunity to have a public discussion about the very, very important ideas that she puts forth in the book. So for that reason, I'm really particularly grateful to you all for giving me the opportunity to represent her work. So I'm actually going to quote directly from her book quite a bit, starting with this definition of childism. So she writes, drawing on comparative studies of prejudice forms, then childism can be defined thus: a prejudice against children on the ground of a belief that they are property and can, or even should, be controlled, enslaved, or removed to serve adult needs. Now, in order to understand this definition, it's helpful to know what is a prejudice. And actually in the book, which I highly recommend that you read, she does explain this in some detail, but I'm just going to pick out a few select quotes. So she describes a prejudice as a developmental problem played out projectively in the world among people. One of the key ways people have of keeping themselves on an even keel is projecting their conflicts onto others. They throw their baggage overboard in a storm. The result is a prejudice. So in other words, people have conflicts or bad things inside themselves, often referred to as baggage. And the idea is that a prejudice is sort of a societal phenomenon where people place those bad feelings in a group outside of themselves. And I'll elaborate that again in a minute. Now, so she talks about childism on many different levels as a societal phenomenon, so it exists on an individual level between individual people, but this is how she refers to it as a societal phenomenon. She writes, at its basis, childism is a legitimation of an adult's or a society's failure to prioritize or make paramount the needs of children over those of adults, the needs of future adults over present adults. And so I think that this explains what I experience in my practice, like why is this okay that this little girl is only being treated by a medication change every 3 months? And Dr. Young-Bruhl would say that's an example of childism. So she actually does speak directly to this issue of psychiatric drugs. She writes, a childism of a sort that is now fueling an epidemic of diagnoses of bipolar II disorder and the prescription of medications to children who are, in effect, being doped into acquiescence. So then she does talk about child abuse as a manifestation on an individual level of childism. And actually, the way she developed these ideas is quite interesting. She was, as I mentioned, a psychoanalyst, so she did this very intensive psychotherapy form with her patients. So she got a very, very in-depth view of their experience. And that's where she came to understand that adults abuse children, and at the root of that is what she writes is that the child is at their service to satisfy their needs and desires. And so that's childism there. But if you go back to what I was saying about what is prejudice, it shows you that this occurs in a relationship. And I'm going to read this quote as well. In the modern field of prejudice studies, a broad consensus has developed among researchers that prejudiced people's negative images or stereotypes are projections outward of hated or feared traits, aspects, functions, or fantasies of the prejudiced person's own psyche or history. So, in other words, something feels bad in the abuser, and generally, and we'll talk about the concept of intergenerational transmission of trauma, generally that comes from their own experience as a child, and then they put that into their child, project it into their child. So you can see from this definition that by its very nature, child abuse has to be understood as a relationship between two people. So now I'm going to, since the topic of the conference is child protection, I am going to talk about child protection. And the way Dr. Young-Bruhl gets into the subject of child protection is she looks at the history of the field of child abuse and neglect. And so she writes of the discovery of child abuse and neglect in the 1960s, and she refers to it as the scientific discovery because certainly it was known about well before that. But really the birth of the field of child abuse and neglect studies came out of this description of the battered child syndrome by a pediatrician, Dr. Kempe, in the 1960s. And so from the very beginning, child abuse was seen as not a disease of the abuser, contrary to what you might think from what I was saying earlier, but a disease of the child. And so what she writes is the name from the start took attention away from abusers and their motivations. Now that's my highlighting, but you'll see that word motivation is going to recur and be very important later in my talk. It implied that children could be helped without their abusers being helped. So now what is the link between the field of child abuse and neglect as a medical field and the field of child protection? She explains that when she writes, Kempe, that's the pediatrician, had launched one of the swiftest transitions from identification of a social problem to legislation in America's history. The states all increased their vigilance by establishing or strengthening child protective service departments. So then she starts to talk about how the way in which the child protection system was created ended up having some components of childism within it. And she writes, since CPS was created as a rescue service, a child-saving service, not a family service supporting child development generally and holding parents, greater efficiency in prosecuting parents was achieved, but not greater understanding of them, educating of them, or working with them therapeutically to prevent child abuse. So now I'm going to share with you a very interesting experience I had. I was invited to teach a class at the Springfield College School of Social Work to the students were well, what's called DCF in Massachusetts, but they were the CPS workers. And so I spoke with them about infant mental health and what I'm going to talk with you about in a few minutes. And then I stopped and I asked them to give me feedback from what I had just told them. And so there was one student, some of these were quite senior people, in the department and had been practicing for a long time. And one of the women was a supervisor of the frontline CPS workers who go into the home when there's suspected abuse. And this is what she said to me. She said that these senior workers who have been there since the inception of the field of child protection see their task as going into the home and proving what the parent has done wrong. Now, I want to say that I recognize that when I'm talking, I'm giving a historical view of CPS, and I'm sure that a lot of this has changed, but I think that it's important to see where you came from in order to understand the direction things are going to change that. So clearly, certainly with these senior people, this kind of frame is still very much alive. And this is exactly what Dr. Young-Bruhl would refer to as a manifestation of childism. And she writes about the Child Abuse Prevention and Treatment Act of 1974. She writes, the problem the bill was really wrestling with was whether and how to investigate and treat parents who were reported for or charged with abuse. The bill counted on sympathy for battered children, but it did not address their batterers, much less the societal and motivational, there's that word again, motivational context in which batterers or any other type of abusers operate. Now, this battered child syndrome was described, a description of physical abuse, but Dr. Young-Bruhl also addresses how this is a common phenomenon in the research on sexual abuse. She writes, volumes of studies of sexually abused children and volumes of studies of the behavior rather than the motivations of sexually abusing adults appeared, but only rarely were the relationships between children and adults seen as serving adult purposes and adult beliefs or prejudice. And I'm just going to say a word about foster care because obviously that's such a huge part of child protection that in a sense this also in part grew out of that concept of the battered child syndrome. So Dr. Kempe wrote a book in 1968, The Battered Child, and Dr. Young-Bruhl describes that in the field of child abuse and neglect, the book is like the Constitution. And in that book, this is what Dr. Kempe wrote. He wrote, at present, there is no safe remedy in the situation except the separation of battered children from their insufficiently protective parents. So that's a historical view that she presents of child protective services. Now I'm going to switch to something else that was going on at the same time, which is really, and I didn't realize that these were exactly at the same time until I started working on this talk, was the birth of this, what's known as the discipline of infant mental health. And there was this really seminal paper written in 1974 by Selma Freiberg called Ghosts in the Nursery, which actually described the first infant mental health program. This is actually, I'm reading this from, quoting from my book, and my book is being marketed as a book for parents, but I actually wrote it more for my professional colleagues to be able to introduce this wealth of really important ideas to people working with young children and families. So this is what that paper is about. A staff of experienced psychologists and social workers went into the homes of mothers who had been abused. By forming a close connection in a supportive and understanding way while these mothers were interacting with their children in their own homes, the staff were able to significantly improve the parenting capacities of these traumatized mothers. Now, this is a preventive model. These are not mothers who were abusing their children, but you can see it's a different frame of trying to understand and help them, these very much at-risk parents who themselves had been abused. So what is infant mental health? So these are a couple of quotes from the Handbook of Infant Mental Health by Charlie Zena, who's one of the leaders in the field. He writes, the relational focus of infant mental health has been the sine qua non of this field from the beginning. Instead of the problem or disturbance being understood as within the child or within the parent, the problem may be understood as between a child and caregiver. And so the field of infant mental health looks to support the young child's ability to experience, regulate, and express emotion, form close relationships, and explore the environment and learn. So now you may have heard these ideas spoken about as intergenerational transmission of trauma. There's a huge literature. This happens to be one particularly good book about this subject, but certainly probably you talk about this quite a bit. But what I'm going to focus on now is really getting an understanding of what goes right, because it really, if our aim is to develop prevention programs, it's really helpful to understand what goes right in order to know how to prevent things from going wrong. So to do that, I'm going to give you a crash course in attachment theory and contemporary developmental research. So, and a lot of this, not that I'm trying to sell my book, but just there's a lot of this is expanded upon in the book. So John Bowlby is really considered the father of attachment theory, and he developed his ideas in post-World War II London, where he observed the devastating effects of separation of children from their parents, both in the war setting as well as at that time children who were hospitalized were separated from their parents. He was greatly influenced by Charles Darwin. He recognized that a secure, safe attachment relationship was really essential to the survival of our species. And then one of his close colleagues, Mary Ainsworth, is considered kind of the mother of attachment research. And she developed something called the strange situation. That's what this is a picture of, which is a very well-validated research tool to study the phenomena of attachment. And so now we've had over 40 years, more than that, 60 years of longitudinal attachment research, and this is summarizing a huge area, but essentially what we've learned is that it's a good thing. A secure attachment, it promotes emotional regulation, cognitive resourcefulness, social competence, and resilience. And then we add to that, in the last 15 years, just an explosion of knowledge and research, kind of at the interface of developmental psychology, neuroscience, and genetics, which is showing how these kinds of early relationships actually protect against the effects of toxic stress and protect against a lot of negative long-term outcomes, not only in terms of emotional health, but also in terms of physical health. And so we really understand so much of the science of how the brain grows in relationships, both in terms of the biochemistry as well as gene expression. Every day we're learning more and more very specific information about that. Now another very important contemporary researcher, this person is alive and well in London. He's at the University College London. And I've been very influenced by his research, where he really wanted to open up this concept of attachment, like what is the essence of a secure attachment relationship, because people had described it as warm, emotionally available, but it's hard to know what that is or how to do it. And so this is what he learned in his research, and this is why I highlighted that word, is that really what's the essence of secure attachment is the parent's capacity to attribute motivation and intention to behavior. And actually what he describes is that is a uniquely human capacity to recognize that behavior has meaning. And so what's come out of all of the research of him and his colleagues, and he works with a quite extensive network of people also in the United States, is that in order to help parents to promote their child's healthy development, people who work with the parents need to help to kind of in a chain-like way attribute motivations and intentions to the parent's behavior. And then that helps the parent to develop the capacity to do that for their child. So you can see this kind stands in direct opposition to how the field of child protection at least developed originally. So now this concept actually has a name in the research world. It's called mentalization. I think it's kind of an awkward word, but that describes a person's ability to attribute motivations and intentions to behavior. And it's also called reflective functioning. It's also called holding a child's mind in mind. And in my book, and for simplicity's sake, I just refer to it as holding a child in mind. Although mentalization is not only between a parent and a child, it's something that occurs in relationships between adults. Okay, so just to summarize everything I just said, secure attachment promotes emotional regulation, cognitive resourcefulness, social competence, and resilience. Holding a child in mind or reflective functioning is a central component of a secure attachment. So when we're working with parent-child pairs to help move development in a healthy direction, what we want to focus on is holding the parent in mind with the aim of supporting efforts of the parent to hold the child in mind. Okay, so I'm just going to give you an example of what this holding the child in mind looks like. So this is like maybe a 20-month-old child, and actually I took this from a website, and underneath the picture it said the defiant child. And now I never met Dr. Young-Bruhl, but I would suspect that she would say that that word defiant being used to describe a 20-month-old is a form of childism. So, so let's look at this picture and approach this child instead from a mentalizing perspective, from a perspective of holding the child in mind. And so it really, I break it down, it's a kind of a core human capacity, this ability to reflect on the motivations and intentions of behavior. And so it has these really 4 key components. So the first is curiosity. So you might be curious, why is the child doing that? And so you would want to understand where the child is developmentally. So at 20 months, children are beginning to recognize their relative powerlessness in the world. So, you know, a 1-year-old has, you know, what Margaret Muller described as a love affair with the world, and they just take off and they run and they own everything, and everything is theirs. And then when they get to be about maybe 15, 18 months old, they say, you know, that's not really true. And actually, Mom can just sweep me up and take me out the door if I don't want to go. And so in a very healthy, normal way, they start to say no, in asserting their own sense of self. So that's where this kind of a child doing what that child is doing might come from in a healthy, normal way, but it might be exacerbated, or that kind of behavior might be increased in certain situations. For example, you know, sort of going from the normal to the abnormal. If there's a new sibling in the house, the child might feel that things are out of control, so they might be more likely to point their finger at their parent and say no. If there's a lot of marital conflict and they're stressed by experiencing fighting in the household, they might, again, have at another level of feeling of things being out of control and be more likely to exhibit that behavior. And in an even worse case scenario, you know, if there's somebody's actually hurting them and they're frightened, you know, then they're even more likely to be behaving in that way. So the next point is empathy in terms of understanding. I like using the word stressed behavior rather than difficult behavior, that understanding when a child does this, it's not because they're being difficult. I mean, if they're doing it a lot, it's because they're stressed in some way, and that means empathizing and really looking at the situation from their perspective. And the third component of this concept of mentalization is limit setting. So it's really actually not appropriate for a child to do this to their parent. And so certainly saying no, you might just ignore it. You might even kind of think it's funny, and just, you know, if you don't engage it, then the child will probably stop doing it. But it's certainly appropriate to set a limit so a child learns that that's not the way you interact with adults. But that leads into the fourth piece of mentalization, which is probably the most difficult, which is self-regulation. Because if you had other people in your life, if you say you're a parent and your spouse talks to you like that, or your boss, or even as a child, if you were spoken to like that and this kind of thing was then followed by a slap across the face, your child doing that to you might cause you to have a surge of stress hormones that actually impairs your ability to think clearly. And so you might react to that child with intense rage when they point their finger at you, which really has absolutely nothing to do with that child. But in order to have a mentalizing stance, or to hold your child in mind, you as a parent need to be able to control your own feelings and regulate your own response. So it's really rather complex, sophisticated task to hold a child in mind. And another great phrase I love is from Dan Stern, who wrote another very important book about infant mental health called The Motherhood Constellation. He writes about the good grandmother transference. And often when we work in situations where there is dysfunction in the relationship between the parent and the child, and we're looking to protect the child, this, I don't know the pointer, but the grandmother, the good grandmother is not in the picture for some reason. And the professional person, whoever it is, who interfaces with this family, has the opportunity to kind of, in a way, to play the good grandmother. And I certainly feel that way in my clinical work quite a bit. So now this idea of mentalization and promoting secure attachment relationships is actually part of many programs around the country. One particularly excellent program is run by Alicia Lieberman in San Francisco, the Child Trauma Research Program, and she has evidence-based treatment for traumatized children. I don't know if any of you are familiar with her work, but she works very closely with the court system in California. Another program, specifically a prevention program, which is at Yale, similar to Selma Freiberg's program, where she went into the homes of these mothers who had been abused. They work with these at-risk moms and go into the homes, but specifically with the task of helping them to mentalize, to wonder and to hold their child in mind, to be curious about the meaning of their child's behavior. So that's specifically what the intervention targets. So these ideas I'm talking to you about, even though they may be new to you, they're very well known within the world of infant mental health and children's mental health services in general. But when Mike first asked me to do this, I contacted a colleague of mine who is a lawyer and did the infant mental health training program with me in Boston to ask her what would be helpful to a group of lawyers. Well, what should I talk about? And she mentioned actually Alicia Lieberman's program as an example of how infant mental health is used in the child protection system. But this is what she said to me. She said, "My reaction to their intervention is that it's so therapist-focused, other states would have a difficult time funding similar plans." So then I got to thinking about how can you use these ideas that I'm describing to you, not as therapists, but just as people at many different levels who interact with these very troubled families. So then I thought I would give you an example from my own practice, because I'm not a therapist. I mean, granted, I have had quite a bit of training recently in this, but where I actually used this concept of mentalization in a clinical interaction. So this is actually more recent. I was in my pediatric practice, and this was this was actually a new ADHD eval. That's what they're called. So this is actually a 50-minute appointment. But the expectation is that in this 50 minutes, I'm going to see this parent and child, and I'm going to find out if they have symptoms of ADHD, and if they do, I'm going to write them a prescription. So that's kind of the expectation. But at this point, I was quite a bit more savvy, and I used this approach instead of holding the parent in mind to help them hold the child in mind. So again, I'm going to change the details just to protect privacy. This was a 9-year-old boy, and so the mom and the boy come into my office. The boy is like trying to hide himself in his coat, and the mom just starts with this barrage of criticism that really actually felt to me like emotional abuse right there in front of me. You know, he's defiant. You've got to get him to behave. You know, I know he needs a prescription because his behavior is so bad. And it was really very, very difficult. And so I had to kind of think on my toes. So what I did first was actually to ask the mother to leave and wait in the waiting room for a few minutes. And so I saw the boy, and I didn't expect he was going to tell me anything about his problems, but I just wanted to develop some kind of an alliance with him, you know, what he likes to do, what he's interested in, how he's doing in school. So we just spoke just for about 5 minutes. And then I had the mom come back in the room. And then I kind of do this thing, which is, I was speaking with a friend of mine who's a lawyer, that the way I approach these visits is actually completely opposite to the way doctors and lawyers actually are taught to think, which is usually very systematic and logical. But instead, I do this kind of Zen thing where I just say, okay, I'm just going to hear what she has to say. And so she started to tell me her story, and she talked about how she had several kids, that a number of years before they had been living in a trailer and there had been a fire. And actually, they were homeless for a while, and she had never told anyone because she was afraid the kids were going to be taken away. She actually never told anyone, I mean, in a professional capacity, until that moment when she was telling me. And then, you know, when she saw that I wasn't horrified and I was just kind of staying with her and seeing where the story went, she started to talk about her own life. And she actually told me that when she was young, she had had a traumatic experience involving a fire, and she actually had a lifelong struggle with very serious mental illness. And the kid, in the meantime, you know, the shoulders had come down, the coat wasn't over his head anymore, and she looked over at him and she said, "It must be so hard for him to see me like this." And it was like this totally transformative moment where she was actually thinking about her son and about how what happened to her was affecting him and about her relationship with him. And the whole mood of the whole thing just completely softened. So that's an example of really holding a parent in mind with the aim of helping them to hold their child in mind. So sort of breaking it down into its pieces. So again, I was, rather than going through my list of symptoms, I was curious about her experience. And I saw that even though she presented herself as a very angry person, that she was really suffering. Then I did set limits on her behavior. I would not allow her to speak about her son like that in front of me. And then self-regulation, for me, is very important. And, you know, I think this is probably something that you all, when you deal with these kinds of families, experience, that when you are confronted with a parent who's hurting their child in some way, it's hard not, you naturally feel very upset and even angry at that person. So managing your own distress and being able to be open enough to actually listen is not easy. So what I love about Peter, this is, you know, fairly complex stuff, and there's a rather extensive literature on this, all of this. But what I love about Peter Fonagy's work is that he boils it down to this thing that he calls a mentalizing stance. It's just a way of being, and it's a way of being not only of a parent and child, but just a way of being with each other. And he refers to it as mentalizing, but really the essence of it is having a non-judgmental curiosity of the person that you're interacting with. So I'm going to actually go back to Elizabeth Young Brule's book for a minute now. And she concludes, you know, towards the end of the book, she writes about what direction we should take to combat childism. And she writes, "We need to recognize that the narrow focus on protecting children to the exclusion of providing for their developmental needs produced a huge distortion in this country. We were relying on concepts that ultimately could not even serve the purpose of protection because children whose development is not being supported cannot be protected." So now she doesn't say anything about infant mental health per se, but she does actually speak at length about this book, The Irreducible Needs of Children by T. Barry Brazelton and Stanley Greenspan. And these, I don't know if any of you are familiar with Barry Brazelton. Anyway, both of these people have had a huge impact on the field of infant mental health. T. Barry Brazelton is actually 94 years old, still going strong. Stanley Greenspan sadly passed away a few years ago. And interestingly, next week I'm going to speak at a conference at his organization. So he's a very big part of infant mental health. So she looks to them and what they write to provide kind of the antidote, a different approach. And so interestingly, you know, in my work, I work with babies, newborns, and I really think that since I have this captive audience of lawyers who might go on to make policy, that to prevent child abuse, we would do well to put a lot of resources into the newborn period, because we have extensive evidence of how the brain grows in relationship with the parent, and the brain grows very rapidly from birth, like 1.8 million connections per second. And what Brazelton did was, in his work, you know, babies had been thought of as kind of lumps of clay, and he recognized this, which I'll just read to you from her book. Each newborn is a unique individual who has already been developing for 9 months and can already make choices and communicate needs. So it is crucial that adults be able to recognize and attend to each baby's unique way of fulfilling the universal maturational and developmental program. And what Dr. Brazelton did was he developed this tool, which is called the Neonatal Behavioral Assessment Scale, which has been modified into something called the Newborn Behavioral Observation System, which is very user-friendly and can be used. I'm doing it now in the hospital where I work, where it can be integrated into teaching a parent to give a bath. And it offers a way not to tell the parent, it's not psychoeducational, it's experiential. And I actually had a little video, which, because of technical reasons, I wasn't able to show it, of me doing an NBO with a mom and a baby. And what's really extraordinary, I mean, it takes like 10 minutes, and the baby at 3 days of age not only makes direct eye contact and follows a gaze, but when in this video, the mom talks, first the mom talks to the baby from the side where he can't see her, and the baby turns to her voice and reaches for her, 3 days old. And then we turn the baby around, and the mom says, "Hi, baby," and the baby, the other way, takes the arms and goes like this. I mean, many people now just have no idea that a baby has the ability to do that. But then what the baby does is, when I speak to the baby and hold him, he follows my face, and then he starts to move his mouth just the way I'm talking. And so if you think that you take a mom who's been traumatized or abused, and she has this new baby, and she doesn't know what to do, and if you think about this idea of prejudice being projections, already there's risk that she's projecting into this little person, you know, attributes that she can't tolerate in herself. So drawing on that, if you were to have the opportunity with this is my fantasy, with every mom-baby pair, you know, because then you get everybody who's doesn't have a sticker on their forehead that says I'm at risk, and show them what their baby at birth, how much they are such a complete human being who has such complex capacity for communication, that I think if we could do that, we would really make a big dent in this problem of child abuse. So I'm just going to, you know, I've given you not really what to do, but kind of a way to think about things. And these are just some ideas I have about how this paradigm of infant mental health might be integrated into child protection. So I think, going back to what she said about it originally being a child-saving service, think of it as a relationship repairing task rather than child-saving task. And thinking of this word holding, another person who's been very influential on my work is somebody named D.W. Winnicott, who described the holding environment, which is an environment in which the parent listens to their baby in this way. And I think that we were talking about multidisciplinary teams. I think this holding environment is important not only just for the individual person who's working with the family, but for the team of people who are working together. As you know, it's very stressful to work with these kinds of families, and so offering the clinicians, the lawyers, the judges, whoever's interfacing with these very troubled families, their own holding environment. And this term, reflective supervision, also comes from the field of infant mental health, which is this idea that in order to be able to listen to the the client, the patient, somebody needs to be listening to you. And this sort of goes up, it actually really needs to come from the top down, this valuing of this kind of listening. The student I had in that class was, saying that that's what she really needed to do as a supervisor in order to change this worker's mindset about proving what the parent had done wrong. Because, one thing that can happen is not only just the projections go onto the child, but they go on to the person who's trying to help them. And that's very difficult. So in the healthcare profession, when I teach residents and medical students, about listening to parents in this way, having this mentalizing stance with parents, the stance of non-judgmental curiosity, they need a place where they can talk about what's happening to them and how stressed they are and how hard this is for them when they hear about a child who's been abused or how parents aren't able to or having difficulty thinking about their child. So I need to listen to them. And I'm just, do I have a couple minutes here? Okay, so I'm just going to give you another very brief anecdote from that class that I taught, where there was this one woman who was just really disengaged with the talk. She just wasn't interested in what I was saying. It wasn't really relevant to her. And then in the second half, I started talking about very specific behavioral issues, and I was talking about sleep and how in infancy babies learn sleep associations, and if they don't learn a sleep association that's not a person, that they actually, on a physiologic basis, have difficulty going from being awake to being asleep. And so as I was talking, suddenly, she sat up, and she was totally engaged. And it turned out that her job was to teach foster parents. So her success was measured by how successful she was in maintaining foster care placement. And what often happened is the kids wouldn't sleep, and so the parents would send the kid back. And so suddenly she said, wow, I've been telling them that it's about attachment, and then the foster family feels rejected because they think they are loving this child, and yet the child still isn't sleeping. And she said, if I can teach them this different way of understanding it, that this is really, in some ways, a physiological problem, then they maybe won't feel so rejected, and maybe they'll keep the child. So that was kind of like I was listening to her, then she was listening to the foster parent, who then, with hope, would be better able to listen to the child. So I'm going to conclude. This is actually a quote from my book, which is, I'm a doctor, so it's more about the healthcare system. The image comes to mind of a set of Russian dolls when the healthcare system allows the primary care clinician time to listen to the whole of parents' experience and to support their inherent wisdom and intuition. Parents are able to be fully present with their child. In other words, the system holds the parents who hold the children. So just for fun, I just changed it to this. The image comes to mind of a set of Russian dolls. When the legal system allows the lawyers, CPS workers, time to listen to the whole of parents' experience and to support their inherent wisdom and intuition, parents are able to be fully present with their child. In other words, the system holds the parents who hold the children. Thank you.
Thank you very much, Dr. Gold. We will now take a very short break of 5 minutes. Yes, right up and to the right. Okay, so we're about ready to start here. Uh-oh. Well, she might be coming back, so. You ready? Okay, folks, let's take our seats and resume with the symposium. It is now my pleasure to introduce our second speaker, the Honorable Gary L. Johnson. Judge Johnson serves as a circuit judge for the 28th Judicial Circuit in West Virginia, which is located in Nicholas County, and he is a leading voice in child and juvenile protection law matters. Judge Johnson currently chairs the West Virginia Court Improvement Program Board, which is commonly called CIP. The CIP is a multidisciplinary group that is funded by both the U.S. Administration for Children and Families and the West Virginia Supreme Court of Appeals. CIP's purpose is to improve court systems in the areas of abuse and neglect. Judge Johnson is also a member of the Commission to Study Residential Placement of Children, a representative to the West Virginia Law Institute, which is directed by our very own Professor Bob Bastress here at the law school, and he also serves on the West Virginia Adjudicated Juvenile Review Commission. Judge Johnson obtained his bachelor's degree and master's degree from WVU, but much more importantly, he obtained his law degree from the WVU College of Law. Judge Johnson will be speaking today on the topic of child protection and the law in West Virginia. Judge?
Thank you very much, and thank you, Dean McConnell, I guess he's down, for sponsoring this today. This is a very important area of the law to me, and I'll try to explain a little bit how I became involved in that. There's the Dean. I just wanted to thank you, Dean, for hosting this Child Protection Symposium. It's really, really important that we bring this to the public's attention. The issues before, when I first started this work, it was sort of secret. Nobody knew anything about it. And we have tried to that's one of the things the Court Improvement Board has tried to do. We've tried to raise awareness throughout the community and throughout the public of the problem that abuse and neglect is. Also, I wanted to tell you that I have two children who graduated also from WVU Law School. One was also editor-in-chief of the Law Review about 5 years ago, and one was a articles editor of WVU Law Review. So I got my money's worth, my tax-paying money out of WVU College of Law. So, you know, I didn't go my first year here. I was on the waiting list here, and we were talking about persistence when we were this morning, and the first year I wasn't a very good undergraduate. My first 2 years, I thought I made up for the third and fourth year, but I didn't. So anyway, I was on the waiting list my first year to get into law school. The first year I applied here. And I ended up going to school in Washington, D.C. instead. I kept waiting and waiting 2 weeks before school started, so I finally ended up going to another law school. But one of my colleagues, Judge Fred Risovich, who was retired by the voters about last term, I think. But anyway, he came and he sat in the dean's office and sat, and I called him and I said, well, Fred, you're on the waiting list. He said, I'm going to sit here till they let me in. So he sat here for 4 or 5 days, and finally they let him in. So I would have used that same strategy had I known it would work. But anyway, I also like to tell a story before I start. And I know that most of you know Nicholas County is a fairly rural area. I left probably 46 inches of snow. We just had our last people get the power on yesterday. So we've been without power for 7 to 10 days. Our schools just started yesterday also. And it's a hunting area. And I like to use a story to illustrate functions. So it's a hunting area, and it's a very big coon hunting area. I don't know if any of you have heard much of coon hunting, but coon dogs are very, very valuable where we live. And we had a guy come into the county, and he was looking to do a little coon hunting for the weekend. So he asked around to see about a coon dog, and they said, well, there's a guy over on the other end of the county that has a coon dog named Lawyer, and you can rent that dog for the weekend. So he went over to check, and sure enough, Lawyer was there, and he was negotiating with the guy. And he said, how much is it to rent Lawyer? He said, oh, probably $50 a day. And he said, well, that sounds reasonable. So they rented him for the weekend, had the best time they ever had. And they came back about a month later, and they went to rent Lawyer again. And they said, well, it's $100 an hour now. He said, a coon dog for $100 an hour? And he said, supply and demand. He said, we can rent him for $100 an hour anytime we want to anyone we want. So the guy decided finally to go ahead and rent the Lawyer for the weekend, and again felt like it was worth it. He'd paid the $100 an hour. So the next time he went back, of course, he went to rent Lawyer again, and the guy said, it's $5 a day. He said, well, last time was $100 an hour. He said, well, he got so good at what he was doing, they took to calling him judge, and now all he does is sit on his ass and bark. So, Anyway, child abuse and neglect law is a very complicated area of the law. And the reason it is, you know, when we do so many things, we do criminal law and we do civil law, and we're pretty much on our own. You know, we do what we want to do, and we either get reversed or affirmed. But child abuse and neglect law is one of those areas where everybody's got a little finger into the pie. That includes the Department of Health and Human Resources, and it is very, very regulated by the federal government. Most people don't realize that. And we got the Department of Health and Human Resources, we got the prosecutor's office, we got the private lawyers who act as guardian ad litems, and all of them have to play a part. Now, the way that the federal government controls abuse and neglect proceedings is through money. And I know that I'm not going to get into inside baseball about this, but they have a provision called Title IV-E, and that's how they fund foster care and child protection agencies in the state of West Virginia. In order to get that money from the federal government, you have to meet certain time guidelines and you have to meet certain rules. And, of course, the federal government, they're trying to make sure that they spend as little money as possible on that, so they enforce the rules very strictly. So in order for us to get Title IV-E funding, there are certain things that we have to do in litigating these abuse and neglect cases in order to make sure that our state agency gets the money it needs in order to protect children and to provide for children. So with that short introduction, I'll explain a little bit about how we get a case in court and what we do. Now, first of all, well, before I do that, I want to talk a little bit about our caseload. In researching for this talk, I was trying to go back. The first year that I could find figures for was 1994. And let me tell you what happened in around 1994 is the Supreme Court at that time said, how many children do we have in foster care in West Virginia? Asked the Department of Health and Human Resources. They had no idea. They had no idea how many children they had had out of the home. They had no idea how long they had been out of the home. So Chief Justice Workman at that time charged us, the judges, to go through our files and determine how many children were in foster care, how long they had been there, and what the permanency plan of those children were. And we found scads, hundreds of children, that people had just placed somewhere and ignored. There was no accountability, and no one knew what was going on, and these children, I just don't know, they didn't receive any services, their parents didn't receive any services. It was really a bad situation. And I think that's when we began the modern era of child abuse and neglect in West Virginia with Justice Workman's leadership at that time. Of course, and I want to, before I go on, recognize every member of the Supreme Court. Every member of our Supreme Court has had an interest in this area, including Justice Davis, who was just reelected, and Justice Benjamin has taken a special interest in this area, as well as Justice Workman. So we've had very, very good support from our Supreme Court of Appeals justices. As I said, the 1994 statistics, there were 674 abuse and neglect petitions filed in 1994. Last year, the last year for which we have statistics, there were 3,135. That's 3,135 children taken out of their homes in this state in just last year. And it has exploded. And you might ask the reason for the explosion. Well, the reason is we have such a prescription pill problem in southern West Virginia. I don't know if you have it in northern West Virginia, but we sure have it in southern West Virginia. And we have a methamphetamine program. Now, the dispute now is, can a drug-addicted parent provide a safe and suitable home for a child? Some Department of Health and Human Resources offices do not think that is a imminent danger situation. Some do, some don't. And there's really a conflict developing as to whether they file petitions in those cases or not. Of course, we don't get involved until after the petitions have been filed. So with that explosion of abuse and neglect cases, the termination of parental rights, I couldn't get an exact number, but it looks to me like there were 17 to 19 times more termination of parental rights in 2012 than there was in 2002, a decade ago. So as you can see, the abuse and neglect caseload of circuit judges has really increased. And I would say in a survey of the judges that I spoke to, we have, it takes about 40% of our time. I mean, we do criminal law, we do civil law, we do guardianships, we do contract disputes, but abuse and neglect now is taking probably about 40% of every circuit judge's time. We have 70 circuit judges in this state in 55 counties, and which is sort of a problem because we have 55 ways of doing things, or 70 depending on which jurisdiction that you're in. But anyway, it's been an exploding problem, and the purpose of a judge in abuse and neglect proceeding is to make sure that a child reaches a safe, suitable, permanent home as quickly as possible. That's our job, and that's what we do, and sometimes we become in conflict with the DHHR when we're attempting to do that. And one of the reasons is because the DHHR is underfunded for what they need to be doing. The Child Protection Service workers is one of the hardest jobs you can have. They're overworked and underpaid, and for that reason, as soon as they can, they usually bump out of Child Protective Service, go to another agency within DHHR where the work's not as hard and the pay's a little bit better. And for many years, I've been a judge for 20 years, and I was looking at that, and I probably had 3 of those guys in pictures back there. I hope that doesn't date me, but I don't know. I was looking, I had Lugar, and I had Professor Cleckley, and it sort of makes you old to see your teachers up on in portraits like that. But anyway. I've been a judge for 20 years come the end of December, and it's the abuse and neglect and prescription pill problem and the methamphetamine has really exploded in the last 4 or 5 years to the point where it's very difficult to make a decision as to which way to go. And I appreciated Dr. Gold's comments, and you know, you have to constantly rethink what you're thinking. I mean, you're always changing, you're always studying and always reading, trying to find out a new way or a new paradigm in which we can approach these issues. The historical development of abuse and neglect law. I began practicing in 1980 when I graduated from this fine institution, and I became a prosecutor in 1984, and that's when I became involved in abuse and neglect cases. Now, a lot of people ask me, why did this become an area of law in which you were interested? And the reason is, if you go back, there's a case called T.C., and the child's name, and I was involved in that case. It's one of the first abuse and neglect cases to go up to the Supreme Court. And when it came back, that was in the 82 or 83, when it came back to the Supreme Court reversed the case, the previous decision the previous judge had made in that case, and sent it back to me. And what it was a physical abuse case. And this father had taken this child's leg and twisted it until she had a spiral fracture. And so the Supreme Court said, and they had entered into some kind of an improvement period. So when it came back to me, I was the new prosecutor. It was one of the very first cases that I had. I said, well, we need to terminate the parental rights of this parent. I mean, you know, you don't twist the child's leg till it breaks and then all of a sudden become a good parent. There were no services in place. So I said, we need to set a hearing. And I remember the judge and my predecessor, the 2 predecessors that I practiced in front of, never terminated parental rights one time. They began in 1968, and this was in 1985. They had never terminated parental rights one time. And in this particular case, I remember the judge said, well, I'm not terminating any parental rights. And he looked at that guy and he said, don't you do that again. And that was it. That was the hearing. And that was the stage of abuse and neglect back in 1985. So I thought, well, this just isn't right. So that's how I became involved in this issue and why I've continued to do it over these past 20 or 25 years. And we have received a lot of help over that time. You know, not only did judges not terminate, I remember there was some of you may remember there was a large verdict against the Department of Health and Human Resources that goes back to that same time, in which a woman, after she attained the age of 18, sued the Department of Health and Human Resources for placing her back with her father who had sexually abused her. And it was sort of the same situation. They all had hearings and everything, and whoever, the judge probably said, don't do that again, send her right back in. And so after she attained the age of 18, before she was 20, she sued the Department of Health and Human Resources. She recovered $5 or $6 million against the Department of Health and Human Resources for placing her back in that home subject to that abuse again. And I could tell you, she was a mess. The reason I knew her is I was terminating her parental rights to her children later on. That's how I became aware of the story, because she never recovered. She never recovered from the sexual abuse that her father had inflicted upon her. But anyway, they ended up settling that case, and that I think the Department of Health and Human Resources ended up paying $1 million to her, and it's really a sordid story because I've dealt with this lady probably since I've been judge, and since she got this $1 million, she did not improve her life one bit. She kept coming back into court trying to sell her that was a structured settlement, and it was structured because she was not very good with money. She kept coming back in and selling, and I would not approve. Circuit judges have to approve it when you sell structured settlements now. And I approved one or two, and then I just wouldn't approve anymore. So she moved to county to get another judge to start approving them. She eventually spent all $1 million, doesn't have anything to show for it, had never helped her children one bit, and she just never recovered from her initial sexual assault. So we were going from a time where parental rights were the paramount. If you look at abuse and neglect, it's a constant shifting of what's in the best interest of children and natural parents' rights to their children. It's constantly shifting back and forth. And at that time, the paramount concern was the natural rights of parents to their children. Children were treated like property. And very few terminations occurred. Now, that all began to change in the 90s, late 80s and early 90s. And as I said, we are controlled by federal acts, and with the adoption of the Adoption Safe and Families Act of 1997, it emphasized to the states that the #1 priority was the safety of children, and the best interest of children should control, and not the natural rights of parents. And it also required some accountability from the states through, again, funding and money. And so that began the modern era in the late 80s and early 90s of child abuse and neglect. Now we terminate, as I said, 17 or 19 times more parents' rights than we did a decade ago. Now, when I look at a case, as I said, when you file a particular case, you begin with the filing of the petition. And the Department of Health and Human Resources is the state agency, and CPS is a division of that agency that is responsible for filing these petitions. Now, individual citizens are permitted under our statute to file petitions, but that happens very rarely. And the prosecuting attorney is the statutory representative of the Department of Health and Human Resources. And sometimes there's a conflict. In some counties, the DHHR and the prosecuting attorney get along fine. In some counties, they do not. And it creates conflict. And the department wants to file petitions. The prosecutor doesn't want to file them. And even though the Supreme Court has said that the DHHR is the client and they have the right to direct the prosecuting attorney, there are many informal ways that the prosecuting attorney can get around that. So there's a conflict there. And we proposed a law in our committee and the Court Improvement Board to allow the Department of Health and Human Resources last time to hire their own attorneys in abuse and neglect cases, and due to financial constraints, that really didn't see the light of day, did it, Catherine? So once a petition is filed, in an imminent danger case, we remove the child upon the filing of the petition, then we have to have a preliminary hearing within 10 days. And the purpose of that preliminary hearing is to determine if the imminent danger that existed at the filing of the petition still exists, and whether the children should remain outside the home pending the adjudicatory hearing. And this sort of tracks a criminal case. You have a petition filed, which could be a warrant, and then you have a preliminary hearing, which you have in a criminal case, a preliminary hearing. And then you have the adjudicatory hearing, which is the actual trial. And it took so long for me to make prosecutors and lawyers understand that this is a trial. You prepare for it like you prepare for a trial. You don't go do it like you do in magistrate court, go pick up the file and come over across the street and go to an adjudicatory hearing. It's a trial. You need to talk to your witnesses. You need to prepare your witnesses. You need to review all the information in the files and prepare like you would for a trial in a criminal case. At the adjudicatory hearing, the court makes a decision as to whether or not the child is abused and neglected, and which is the abuseful and neglectful parent. And probably at the adjudicatory hearing, there are very few cases where parental rights are terminated directly from an adjudicatory hearing. In 9 out of 10 cases, the parents are always given an improvement period or a chance to improve, because that's what we want to do. The purpose of the whole proceeding is to make sure that we could put children back in their home with proper services where they could be treated like human beings. Now, and as I said, I was trying to think of the different ways when the doctor was speaking of different types of abuse and neglect cases. Of course, we have sexual abuse cases, and those are easy. I mean, you terminate and that's it. That's called an aggravating circumstance under our law. And then there are physical abuse cases, and depending on the severity of the physical abuse, you may grant an improvement period or you may not. And then there's the abject neglect cases. Those are the cases where the parents, due to economic conditions, or not economic conditions, but due to their limited mental abilities, just cannot raise a child. Their houses are filthy, and they just don't know how to raise a child. And those are the cases that really break your heart, because these people love their children and they want to help them. They just don't have the ability or the capability to do so. And those are the cases where you really try to put in the services and really try to help them so you can keep that family together. And then 90% of our cases are substance abuse cases. And in those cases, we always, I would say 99 times out of 100, you grant an improvement period, you send them to a rehab program, you try to help them, and try to make them be better parents. Now, those parents at some point in time are going to have to choose. I was speaking last night at a social workers conference down in Beckley for the Department of Health and Human Resources, and Judge Swope, who is from Mercer County, he put it this way. He said, I know it's difficult. He said, those of you, he was telling the audience, he said, those of you who have tried to quit smoking, or he said, I'm a diabetic, I can't have chocolate. He said, it's even hard for me to give that up. To give up an addiction that is as strong as an opiate addiction is very, very difficult. So, and one of the problems is we don't have local resources to do that. But we do the best that we can, and try to help these parents keep their children. And I would say that we're not greatly successful, but we do have some successes in trying to get children back in their parents' home. Now, our responsibility, once that improvement period is granted, is to review that every 30 or every 90 days, which we do, to make sure that the department is providing the services that they need to provide and that the parents are cooperating with those services. So we review those every 90 days, and I was looking at statistics when I was preparing for this. We have, when you do a hearing every 90 days in a case, and you have, I have 84 pending cases right now of abuse and neglect. So you can imagine if I do those every 90 days, how much time that takes up. And but they're very, very worthwhile, and we make sure that everybody's doing what they're supposed to do. Now, as I said, the opiate addiction is very, very hard for people to kick, and I would say in a majority of those cases, in the end, we end up terminating parental rights. And it's a very, very traumatic to the parents, to the children, and to everybody involved. But I think it's more traumatic to leave them in their homes. I mean, that's just my personal opinion. I don't speak for the Supreme Court or any other judge, but that's just my personal opinion. What I try to look at is, an addicted parent, every penny that comes into that home goes to feed that addiction. They don't care about food. They don't care about appropriate shelter. And I think every kid deserves the right to have a decent place in which to lay their head every night, both as to a place and to people. One of the problems with these homes is that people are coming and going all night, and a child needs a good night's sleep in order to perform in school. If they don't get a good night's sleep, they don't do well in school, and then they end up dropping out of school or become truant later. So I think every child deserves food, shelter, a good night's sleep, both an adequate place to sleep, and with people not running in and waking them up all night and partying all night. So that's what I base my decisions on. I know that not all judges agree with that. We have a couple of judges in this state still today that have never terminated parental rights, not one time. And it's just their philosophy that that's just not something they want to do. And so they don't do it. And we were talking, the Court Improvement Program sponsored judicial roundtables regionally where we tried to go around and heighten judges' awareness of the issues with children. And one of the judges said, well, I've got 1,000 pending cases. And the people we brought in to moderate it said, well, how could you have 1,000 pending cases? he said, well, he said, I need some help. I just can't get them all done. And so we found out that the reason he has 1,000 pending cases is he'd never finished any of them. He'd never terminated parental rights, and some of them had gone on for 6 years, some of them had gone on for 7 years, and it's really, really a bad situation. So part of our job on the Court Improvement Board is not only to educate lawyers and educate social workers, but to educate judges about their responsibilities. And we do that. One of the things that we've really been lucky in that the Judicial Association has now given us, and this was not always true, you used to have to fight for time, but they now give us at least 2 hours at every judicial meeting to talk about abuse and neglect, and we've certainly taken advantage of it. We bring in national speakers sometimes. We bring in judges from other states, and we really try to train our judges, and some of them take, some of them don't. So, you know, it's just a hit and miss situation, but we try to train them and improve them the best way that we can. Some of the differences between the old way that we did things and a new way that we try to do things now is the old way, and when you talk about shifting paradigms, that's what we're trying to do. We're trying to shift the paradigm so that we can see these cases in the eyes of the child so that we can get them in a permanent place. And one of the other things that was said at the conference that I was at last night, and that this is very true, you know, I'm 60 years old, so a year in my life is 1/60th. But a 5-year-old child, you take that child out of the home for 1 year, that's 20% of his life. So it's a different construct when you have a child. In the old system, foster care was an end in itself. With the new federal legislation, foster care is a temporary service. Every child deserves a family as quickly as possible, whether it's biological family or legal family. Now, we have 4 dispositions that are possible in an abuse and neglect case. Number 1, and the most preferred, is reunification. That doesn't happen all the time, but that's the preferred one. And absolutely adoption is the best thing that can happen out of these. Sometimes we end up with the guardianship for various reasons. I think a child over 14 has to consent to the termination of his parents' rights, and sometimes they just don't want to do it, so we end up in a guardianship situation rather than an adoption situation. And the other one's a planned permanent living arrangement, which is not a preferred disposition by anyone, but sometimes it happens with older children. Now, I wanted to tell you a story about an adoption I did, and this work is very frustrating sometimes, but you do have successes sometimes. I terminated this was a 12-year-old girl, and she had a 9-year-old sister, and her mother was a drug addict. And we'd been through the improvement periods, and we tried, and it just didn't work out. So this 12-year-old had taken over the parental responsibilities, the mother responsibilities in this home. She cared for her little sister. She made sure her mother ate. I mean, she was the mom in that home. And she was really, really upset with me the day I terminated her mother's parental rights. And she came up to me afterward, and she said, I'm never going to forgive you for this. And so I said, I hope that you will someday. But anyway, about 5 years later, she went through the process, and she went to a wonderful adoptive home. And about 5 years later, she came to me and asked me to write a letter of recommendation for her. She was applying to the U.S. Military Academy, and she was accepted. And that never would have happened had she not gone to that new home. And I sort of get emotional about that because that's one of the very big successes I have, and I still see her on occasion, and she thanks me now every time I see her that she got in that new home. So sometimes you do have those successes like that. So under the new role, we try to get them out as quickly as possible out of foster care into a permanent situation. Now, another problem that we have is we are leaving, if there are older children involved, and usually in an abuse and neglect, it has to be really, really, really bad for you to terminate an older child. And but through that process, and also through the juvenile delinquency process, we have many, many children aging out of the system at 18. I just wanted to mention this. This doesn't apply solely to abuse and neglect, but it's really a problem that we have. We in West Virginia, the Chafee Act passed in 1999, and that was so the federal government would give transition money to states for 18 to 21-year-olds that are aging out of the system. Now, when you were 18, what we were doing, which was a crime in itself, we would turn 18-year-olds out into society and say, you're on your own. At 18, could you all take care of yourselves? Could you provide for yourselves? I doubt that very many of you could. I know I couldn't. And and we turned them out without driver's license, We turn them out without means of support. We turn them out without places to live. You know where they end up? Back in the abusive home they left to start with. So the Chafee funds help 18 to 21-year-olds transition to a permanent independent living place. So we last year in West Virginia, this is really a crime too. I can't catch how much money did the state turn back in Chafee funds that they did not use. It's some hundreds of thousands, $600,000-$700,000, because no one was aware of the program, didn't use the program. The state just turned it back to the federal government. So what we've tried to do, we have in May set for, again, a Judges Association. We have a national expert on Chafee funds coming to instruct the judges how you use those funds, what they can best be used for. And the reason the statistics are staggering of those children who age out of foster care. 1 in 4 end up in jail within 2 years. So if you age out of the system when you're 18 without any permanent home or anything to do, there's a 25% chance you end up in jail within 2 years. 1 in 5 become homeless within 5 years. Only 58% get a high school diploma by age 19. And, of course, we know what that means, and only 3% earn college degrees of those children who age out of foster care. So what can we provide for them? What we need to provide for them, we need to provide adequate housing for them. We need to provide financial literacy and security. You know, you'd be surprised how many of these kids, parents have applied for loans in their kids' Social Security number and ruined their credit by the time they're 18. You know, these kids get Social Security cards when they're born now, and their parents use their Social Security cards to borrow money and ruin their credit, and there's no way that they can borrow money when they turn 18 years of age. And so what we have started doing, or I've tried to do, is I try to change their Social Security number, and the federal government allows us, we send a court order down to get us changing their Social Security number so they can at least get a fresh start and be able to have a decent credit, the decent credit any other 18-year-old would have. We need to assist them in obtaining gainful employment, and we need to assist them in Chafee funds pay for their education. It's like a scholarship. They'll pay for your housing. They'll pay for your tuition. If you graduate foster care 18, that's all free to you, whether it's a academic institution or whether it's a vocational institution. And we have been turning that money back. And, you know, you need to mature. No 18-year-old is mature. You know, as I said, I've been on the bench 20 years old, and I can tell you, you know, I was 25 and wasn't very mature. You know, I was lucky I married a good woman who helped me mature myself, but I was not mature even probably at 24 or 25. So that's something that we really, really need to work on in this state. And I saw Delegate Fleshauer over here. Congratulations on your re-election. And she's really a true friend of children in the legislature. If we have an issue down there, we can always depend on Barbara to come and help us. So I just wanted to give her a shout out. That's it. Okay. So what some of the developing trends that we have now are, as I said, we're trying to develop this Chafee program for the 18 to 21-year-olds, and the legislature last year passed a law that says that we're to review cases of children in foster care after they turn 18, not for the purpose of reviewing them, but for purposes of reviewing the department to make sure the department is doing what they're supposed to do and providing them these transition services between 18 and 21. That's really not taking effect fully throughout the state, but it will over the next 12 to 18 months probably. Now, some other developing trends, as I said, the federal government, and how much time do I have left, or do I have any? 5 minutes, okay. I just want to talk a little bit about some of the things that we're doing in CIP right now. You know, we have the adoption of 0 to 5-year-olds occur very easily, usually. It's the adoption of the 15 to 18-year-olds that have a hard time occurring. And we have funded now what we call, Georgia had a program called the Cold Case Program where they hired lawyers and social workers to go review all the children in care over between 15 and 18 to see if they could find a permanent home for them. So we have obtained funding already, and we're calling it the New View Program because cold case sounds like a murder trial. So we've changed the name of it to a New View. So we're going to hire lawyers, that the Supreme Court is going to pay. We're going to hire social workers, and they're going to take these 15 to 18-year-olds, and they're going to review them and make sure before they leave the system that maybe they can find a permanent home, somewhere to come home for Thanksgiving, somewhere to come home for Christmas, and to have a family that they can ask for advice or turn to in times of need and stress. We also are beginning, I don't know, and this is a little inside baseball, but Title 4E compliance requires orders be done in a certain way, and we have developed a web-based program where judges and prosecutors and guardian ad litem can go in and find form orders that are correct under the law to make sure that the state gets the maximum amount of 4E compliance. We are continuing our leadership collaboratives to try to get judges to meet with their collaborative groups on a local level. That would be their DHHR people, their education people, and we're trying to fund those. We have begun this year guardian ad litem training. I think we're having one here in Morgantown, and when is that? In December? November? Pretty soon. Okay. And we have one in Charleston and one up here, and we're giving guardian ad litem trainings for those people who represent children. But the next to the class that we funded up here, the most important thing that we did was the database. Every judge now has a database so he can see how he or she has been disposing of their cases. And I was at a national conference one time, and we had a lady judge from Cincinnati, and she said, "You want to improve your timelines? Measure them. Because every time you measure something, people will improve." And that's true. And, you know, these are public record now. If you want to see how your judge in your county is doing about his timelines on abuse and neglect, you go on the Supreme Court website or the Court Improvement Program website, and you look, and it'll tell you. But I think we've been greatly improving. I have brought a demonstrative aid just to show you. And these are like times to adjudication. You can see where that's going down since we started measuring. Every time frame has gone down since we started measuring them in 2007. And some have gone down quite substantially. The one that I'm most proud of is that and we do pretty well nationwide on this, the time to permanent placement. And we're doing very well on that. We're getting children in permanent place. I think we're in the top 8 or 9 in the nation in getting children in permanent homes and getting them established. And so that's one that I'm very proud of. So as you can see, we have lots of challenges, and we're trying to work on solutions, and we will continue to do that. And I wanted to say about Professor Munster before I left that there's no major area of child abuse and neglect law that has gone through the legislature or the Supreme Court that she's not been involved in over these many years. And she's been a true advocate for children and has for many, many years, and I hope continues to be for many years to come. And so all of us working together, the community, the judicial, the judges, the Department of Health and Human Resources, the social workers, the community, the education people, all of us working together can make lives better for West Virginia children, and that's what we're trying to do. So thank you very much.
Thank you very much, Judge Johnson. We will now take another 5-minute break and resume at 5 to 11. Okay, if everyone can take their seats again, please, and we'll continue. Our next speaker this morning is Miss Margie Hale. Ms. Hale is the Executive Director of West Virginia Kids Count, a position that she has held since that organization's founding in 1990. Kids Count is an organization that aspires to the vision of making, and I quote, West Virginia a great place to be a kid. I love that mission. Kids Count serves this mission through projects to educate parents and policymakers on the needs of children. These projects include, but are not limited to, projects to support early literacy, efforts to increase the number of accredited child care centers in West Virginia, and projects to educate new parents about brain development in children. Kids Count also publishes a highly regarded data book on child care needs that is used by West Virginia's policymakers and educators to better understand and meet the needs of our children. Ms. Hale is also active in a number of child advocacy and steering groups, including the National Kids Count Steering Team, and she was a founding member of West Virginia's Board of Social Work Examiners. She received her bachelor's degree in developmental psychology from Marshall University and her master's degree in social work from West Virginia University. She will be speaking today about data concerning child abuse and neglect in West Virginia. Ms. Hale?
Thanks. What do you think? Can you hear me? Yes. Oh, good. Thanks for inviting me, and I wanted to recognize Travis briefly. Travis and I talked on the phone a lot for several months, and my assistant would come in my office and she would say, Travis is on the line. Everybody would sort of laugh, and I would talk to Travis. He took care of me, and I really appreciate it, and you deserve an A+ if this is a class. And I'm glad to meet you, Michael, the other helper. I didn't know he was so gorgeous. Would have talked to him some more. Well, this is going to be exciting, most exciting presentation here today because it's about numbers, and everybody loves numbers, right? Right? Who we are, I want to tell you a little bit about who we are. We were established by Governor Gaston Caperton in 1990, and he was a businessman who was not a politician, and he became governor, and he's one of those people we call a good governor because he didn't go to jail. And to get a glimpse into the past, one of his objectives was to have a computer in every classroom. A computer in every public school classroom. Doesn't that sound old? But we were created as a result of a campaign pledge that he made to bring the private sector into partnership with the public sector to help improve the lives of children. As someone said, our vision is to make West Virginia a great place to be a kid. We sort of played with different ones over time, and we think that it's something that anyone can understand. You know how people have esoteric missions and visions, you don't understand what they mean, but making West Virginia a great place to be a kid is pretty understandable. Our mission is to provide the most trusted data about the well-being of children and to form alliances to advocate for what kids need. We had a recent example, I don't know if any of you heard about this, but the state was going to cut back child care subsidies. Child care subsidies help working parents afford the high cost of child care. And it was going to be cut back really big. And so we organized a coalition of people and spread the word out all over the state. The governor got all kinds of cards and letters, and he lifted the freeze. We succeeded. There's still more cuts to come, but am I supposed to be turning these things? I am, right? Here we go. So that's that slide. This is our data book. It's our signature program. It tracks health and education and social indicators to draw a portrait of how kids are doing in each county. And it's often the basis of public policy. I was hoping Barbara would be here. And it's an important resource for people who seek funds. Like a person would live in a county and they have high poverty, and they can use this to justify the need for money for a project. Oh, I'm already there. Okay, we don't do a lot about abuse and neglect, but every year we collect the victimization rate. Those are the families that where the kid, where the abuse has been substantiated. And the State Department of Human Service gives it to us, and we put it in our data book. Now, I'm going to show you the data book later. Am I going backwards? Now, this is interesting. This line graph, you'll see, oh, I'm not so good at this. You'll see here, oh, I wanted to point at it. I guess I need my pointer, right?
You want to help you with the clicker?
Yeah.
Okay, sure.
The yellow line is West Virginia, and the red line is the United States. And you'll see, this is abuse and neglect, victims, and you'll see that both the nation and West Virginia are on the same trajectory. It's supposed all going down. Some people ask us a lot of time, is there a correlation between the indicators that you find and other indicators? And so I got a new staff person who understands data. And she made this for me, and it's interesting. These are not causative, but you'll see here, abuse and neglect, when it is high in the county, children in poverty is high, teen birth rate is high, free and reduced price meals is really a proxy measure for poverty. You're about 185% of the poverty level if you get this service. So, and low birth, well, no, high school dropouts. So these are risk factors, certainly, in the literature, but you know, there are all kinds of risk factors, and these aren't causative, but I wanted to see if there was a correlation between abuse and neglect. This was Travis's favorite slide. This is the best source of data, national data, and this is where all the states pull their data and send it to them, and it's called the National Child Abuse and Neglect Data System. Anything you'd want to know about abuse and neglect would be there. This is our data book, and we're going to go online in a little bit to take a look at it. There's also a Kids Count Data Center, which is a repository of all the data collected by all the states and also collected by the Casey Foundation, who's the founder of the Kids Count Project. And you can do maps and line graphs and all kinds of stuff. Also, there's a data center mobile app. So you can download all this data. When you're sitting in the classroom, somebody asks, what's the unemployment rate? And you can find it and tell people. Isn't that exciting? Okay, we're going to download the data book, and I will show you a couple of things.
You want to go to the data center after
Back to my home page.
Okay. You take us right here.
I'll do that. This is our home page of the Kids Count Fund, and you can get to the data book by clicking on it here. I've gone really far. Okay. On page 8, page 8, hit 8, page 8 here. Great. I thought you'd be interested, since the Kids Count program is a national program, and there are grantees in every state, and they do the same thing we do. They track child well-being county by county, and the red states are the poor states. The blue states are the rich states. Blue states are the liberals, and red states are I wanted to also show you the West Virginia map. I think it's these are the county ranks, okay. And you'll see the same pattern in West Virginia. Southern West Virginia has the most poverty, the most child well-being issues, and the northern part of the state is different. And there are actually two West Virginians, I guess you all know that. Southern West Virginia is completely different from northern West Virginia. I wanted to show you Monongalia County. I think it's the next one. Yeah. Yeah, 42. I don't know if I told you, but we rank the counties from best to worst. And this is the kind of catchy thing that attracts the media, and we get a lot of stories. So it helps educate the public with more stories in the media. And Monongalia County is #1 in the data book. #1. Can you believe that? Y'all believe that? You can see on the worst and better that it's getting worse on infant mortality. That's very surprising. And on child abuse and neglect, it's getting better. On percent births to unmarried teens, it's getting worse. High school dropouts are good. The percent of children in poverty is better than anybody else. And here you can compare your rank. I lost my thing. You can compare your rank with the state average. And I think Monongalia beats all of them, I think. And you see the ranks there in the 1, 2, 3, 4th column. And there are a lot of places where Monongalia County is #1. The thing of it is that #1 doesn't mean a lot. Because we've made a lot of progress, but compared to the nation, the national averages, it's not good. And I don't know what we can do to make that different. We think at Kids Count that we need a big investment in early child development so that young kids can get enriching experiences and succeed in school. And there's data to support that. And actually, it's the biggest economic development tool you could use. But we can't, who was I talking to who said that the legislators weren't interested in this? Was it?
That wasn't me.
Oh, it was the chocolate woman. The chocolate woman. Which she said that the reason we don't have good early child development is because the powers that be want to keep everybody stupid, so they'll go. Okay, we're going to go to the data center from the home page. I'm glad Barb is not here. Yeah, I want to go. Okay, I'm going to show you here how the data center works. we're going to make a line graph, and you go down here to choose your indicator, and you can see how many there are. And abuse and neglect is in safety and risky behaviors, I think. Child abuse and neglect, you see all the other indicators. And then in terms of child abuse and neglect, you can see how many children were subjected to an investigative report, how many are victims of maltreatment, all different kinds of things. And we are going to look at the victims. This is the same. This is supposed to be. Okay. I'm going to compare this to West Virginia. You could do any state. You guys get to take a nap. Okay, I got to add that to the location. And then we will do a line graph. And it's the same one that I showed you earlier. How do I get that to come down? So there's a line graph, and you can see under it, it has NA. I guess that's the early years. We didn't have that data in the early years, but we got started getting it later. Well, that's it. Thanks for inviting me.
Thank you very much, Ms. Hale. We're going to take another quick break and then come back with our penultimate speaker, Professor Fershee. Our faculty just this year, and we are thrilled to have her as part of the law school's family. She is an expert in family law, and she has written extensively on that subject. Her scholarly work has appeared in the Hofstra Law Review, the Indiana Law Review, the Maryland Law Review Endnotes, the Tulane Law Review, and the William and Mary Journal of Women and the Law. And she has presented her scholarship at various conferences and colloquia nationwide. Professor Fershee obtained her law degree from Tulane Law School in New Orleans, where she served as senior managing editor of the Tulane Law Review. And that means she knows just how hard all of you have worked on today's excellent symposium. After law school, Professor Fershee practiced commercial litigation in New York City and in Washington, D.C. with the law firm of Milbank, Tweed, Hadley, and McCloy, and during practice she also represented clients on pro bono matters concerning disability rights and family law. Professor Fershee's presentation today will channel the spirit of Dr. Seuss. It is entitled "A Parent is a Parent, No Matter How Small." Professor?
Thank you very much. I'm delighted to be here to talk to you. We didn't necessarily, I know that Amber and Travis and Michael had in mind a vision for the panel today, but I don't know that anybody realized how well our topics would marry because there are so many different iterations of child protection. But I think that we have a nice sort of complementary set of topics today that's been really exciting to be a part of. So I'm really happy to be here. My paper, my topic, borrows from the Dr. Seuss. It actually wasn't the title of one of his books, but was a famous phrase from Horton Hears a Who, which is a person is a person no matter how small. And my idea to co-opt Dr. Seuss, which I think you should always do when you're talking about children, is steal something and use it for yourself from someone who's very famous, is that parents deserve the same sort of respect and deference no matter how old they are. So while the title is a parent no matter how small, what I mean is a parent is a parent no matter the parent's age. And I have a few sort of reasons for that position. Adolescent parents are parents, obviously. They have, given birth to a child or fathered a child at a young age, but they happen to not be at the age of majority yet. So they have particular challenges in society that make it harder for them to be effective parents in many respects. And so they have hurdles that adult parents don't, and adult parents certainly have challenges. I can share anecdotes from my own morning just today to tell you that we all have our challenges in life, but that adolescent parents actually have more hurdles than most parents because of the infirmities of their age, their legal restrictions on them as youth, as minorities, they have not yet reached the age of majority. And I think that there is a risk that courts could treat adolescent parents or do treat adolescent parents as more of a risk to their children than is appropriate. And as Dr. Gold was saying, I think childism may have something to do with this because, in fact, when we're talking about adolescent parents, we're talking about children both at the parent stage and, of course, the parent's child. So we've got this concern about youth, both with respect to children and their parents because they are both so young. It's hard to know exactly how often parents who are adolescents are treated more harshly in the legal system than their adult counterparts, but anecdotally there is some evidence that adolescent parents have more of a challenge when they are in the system, shall we say, because of concerns about their parenting. And one example I can give of that, of the anecdotal evidence of young parents kind of having challenges and being put into the system maybe before it's appropriate or being treated more harshly once they're in the system, there is the example of the Catherine Ferguson Academy in Detroit. Now, Detroit is nationally known as a place where poverty and all sorts of social challenges are prevalent. And the school system in Detroit is besieged. It is a very, very, very difficult school system to be in and succeed in life because they've just lost their funding is so weak. But the Catherine Ferguson Academy is one of only 4 high schools in the country that caters to pregnant and parenting teenagers. And in order to get into the Catherine Ferguson Academy, you have to have had a baby or you have to be pregnant, period. That is the criteria. It's a public school, and you don't have to go there if you don't want to, but you can if you are a parent or are pregnant. So it's actually one of the most amazing schools that you'll ever hear about. The principal is a woman who has extremely high standards for the girls in her school. She will not allow them to graduate unless they have been accepted to college. 92% of the graduates enroll in college, at least do some period of time in school. Many of them graduate from college, all while parenting. And the school has a farm, a working farm, a dairy farm. It has an apiary where they collect honey from bees. They have obviously a child care system that's an excellent child care program where kids are catered to at their age level, the babies and the young children of the parents who are in school. And all of the things that are going on in that school are going right, yet Principal Andrews has set up a system where the school days, Monday through Thursday, are longer than most regular school days so that the girls can have Fridays off every week so that they can schedule doctor's appointments for their prenatal care or pediatric appointments as necessary, or court appearances, because they are often in the system for one reason or another based on an accusation of abuse or neglect, which is surprising considering how successful these young women are at balancing the challenges of youth and parenting. So even at this school where the students are thriving, there are young women who are in the system and trying to fight for their rights to maintain their relationships with their children. So what happens when courts, I think, are more assertive than they should be with respect to young parents is that families are separated when it may not be appropriate, and there's an opportunity missed to offer support and services to those young parents that would have maybe cured a problem that is actually not at its core bad parenting, but is related to immaturity or simple legal restrictions on how young people can engage in society. Young people don't have all the same rights as adults, and so being a parent while you are restricted from being a fully engaged member of society is incredibly difficult. So this goes back to the notion of the fundamental right to parent. In constitutional jurisprudence, the Supreme Court has made clear actually as of 2000 in the most clear sense, the Supreme Court has said that parents have a fundamental right to parent and direct and control the upbringing of their children. And also that parents who, this pendulum has swung on this, that there was a time when parents had complete control over their children and could act however they wanted, even if it was abusive or neglectful, to a hyper interference with the notion that parents, if there was an accusation of abuse or neglect, separation was a quick response to that and perhaps premature. Now we seem to be settling in the middle where we are trying to be a little more careful about the assessment of a parent's parenting skills before we do something as drastic as terminating parental rights, which is good. So I came up with this theory that I call the pig pen phenomenon, again borrowing from children's literature, if you could call it that. Pig pen, as you might remember, is the Charlie Brown character who's adorable. He's just but unfortunately he has this cloud of dust that goes with him everywhere. In fact, there's one episode where he goes out in a rainstorm and steps back inside, and instantly the cloud of dust is back. He just can't shake it. It's with him at all times. So pig pen, I think, represents young parents, and that young parents can't shake the dust that follows them when they become parents at a young age, either through a perception by society that they are incapable of being good parents, or because they simply are not allowed to engage in society the way that adults are, that there are stigmas that come along with adolescent parenting. If you think about the numbers, and I don't actually have exact numbers, so I'll just tell you that in broad brush strokes, that the amount of money that is poured into the prevention of pregnancy as compared to the amount of money that is assigned to parents who are below the age of 18 is wildly out of proportion. Pregnancy prevention is easy. It's easy to get on board. People could say, yeah, let's throw some money at that. Let's stop pregnancy from happening for teen pregnancy. This is a huge problem. It creates all sorts of societal ills. Let's dump some money on that. But the second someone becomes pregnant, despite all of those dollars that are poured into fighting teen pregnancy, she disappears. She has no resources. She has very little intervention. She has very little, attention from anybody. In fact, the norm up until the 1960s was to literally hide her. My dad said in his school there were always girls going off to take care of their ailing aunt in Rhode Island. Everybody knew what that meant, but that's what you said. They just went away. And there's a book called The Girls Who Went Away that focuses on this phenomenon. But we haven't come that far from that. We still have the society that doesn't want to accept the fact that despite all the money we pay to prevent teen pregnancy, we are always, I don't mean to be, negative, but we are always going to fail to prevent every teen pregnancy. There will always be young people having kids. And so when that happens, what do? We are very negative. We are very judgmental. We are very punishing of those parents and want them to feel like they've made a mistake, and we don't support them in the way that we should. But there are correlations between young parents and negative outcomes for themselves and for their children. There are economic disadvantages that come along with, the causation piece is tenuous. There were arguments in the 80s it was very popular to say teen pregnancy is causing social ills. It's causing economic problems. It's making people fall into poverty. It's making them engage in criminal behavior, et cetera, et cetera. But the causation, when looked into more deeply, appears to kind of crumble, and it may be correlative that these two things tend to go together, but teen pregnancy is not causing necessarily these ills. But we do see that there are economic disadvantages, struggles with education, poor child care options, poor work options, and more for young parents. Children born to adolescent parents are more likely to struggle as well. They have educational disadvantages. Boys are more likely to become incarcerated as they grow up. Increased exposure to negative life events, poor home environment, poor cognitive development, and more. And then society does suffer when we have, although there are some arguments that because young parents having children at an early age gets them back into the economic mix, that they actually will be paying taxes for longer than most people, so that they actually might benefit the economic pot over time. But there are, in terms of societal ills, there are higher rates of incarceration, which do cost taxpayers money. So teen pregnancy is something that we should be aware of. Teen parenting is something we should be aware of. But I don't think, and usually I'm very positive and optimistic, but I don't think we're ever going to stop the problem. So we need to, at the point of stopping people from becoming pregnant, so we need to really focus on how to support young parents when they find themselves in that situation. But here's the other thing. Parents have constitutional rights to parent no matter how old they are. There's no asterisk on the Supreme Court cases that say parents have a fundamental right to direct and control the upbringing of their children. That says, but if you're under the age of 18, you actually do have some limitations on your rights. There is no asterisk. So those parents should be protected the same way that adult parents are once they get into the system. But people who are under the age of 18, as we all know, do have infirmities, legal infirmities. They're not allowed to do everything everybody else gets to do. They can't vote. They don't have the same First Amendment rights. They have different Fourth Amendment protections. They're more limited. Their due process rights are more limited than those given to adults. The Supreme Court has said in certain circumstances, children can be treated differently from adults. So they have the responsibilities as parents that every parent has and should have, that's appropriate, but they don't have the opportunities and the rights to engage in society like an adult parent does. So there seems to be a little bit of a disconnect between what's going on in reality with how young parents are parenting or how they're going about their attempt at parenting, and the belief that young parents have all of the same rights that that adult parents do. Because there's a quote that I like to highlight from Bellotti versus Baird, which is a Supreme Court case actually about reproductive rights for people under the age of 18. But the quote that the Supreme Court said, and it's sort of, it's dicta, it's not part of the holding or the reasoning, but the court sort of goes off on a little tangent and says, the fact of having a child brings with it adult responsibility for parenthood, like attainment of the age of a majority, is one of the traditional criteria for the termination of legal disabilities of minority. So the Supreme Court actually said once you become a parent, that's a criteria, traditional criteria for the termination of legal disabilities in our society. But that there's no actual, there's no citation behind that statement. It's not that that is taken from any specific example. For example, if you're 16 or 15, let's say that, if you're 15 and you have a baby, that doesn't mean you get to go into the DMV and say, oh, I should be able to get a driver's license because I have a baby. Oh, and I'd like to vote too. I mean, there are other things, obviously, signing leases, being able to get a job, and having responsibilities at school that certainly are, we know, are challenges for young people, especially for young people who have children. So these impediments make it so that there are times when young parents maybe are unable to be as attentive or as involved in their children's lives as adult parents, and we should recognize that and offer resources to kind of help combat maybe immature decisions that they're making or decisions that they have to make based on their legal status. So I have this part here about the constitutional rights and due process clause adjudication and equal protection. I'm going to skip that so we can pick up some time. Not that it's not important, but it gets pretty technical, and the arguments that I'm making are that can be summed up with the argument that the Constitution does protect parents no matter how old they are, as I've already said, and if courts and the legal system treat them differently because of their age, that is an inappropriate use of power, and that the Constitution does not permit that. So what I'd like to talk about briefly is my suggestion for at least one thing that maybe would help solve if there is a problem with courts treating young parents as a factor in terminating their parental rights. Perhaps what could happen to help ameliorate that issue is for states to consider adding a best interest of the child factor to the balancing factors that courts use to determine whether children should remain with their parents. And the best interest of the child factors are meant to sort of take into account many things that are going on in children's lives and parents' lives. And they're meant to sort of not favor one or the other, but reach the best outcome for children and parents. So what I would suggest is that a best interest of the child factor that suggests that youth is a legal infirmity for some parents, that some parents have not reached the age of majority, and that challenge might actually contribute to whatever bad behavior, quote unquote, they engaged in to get themselves into the legal system in the first place, may be something that the court could help with. That those infirmities could be something that the court could say, I see that there is a need for support in a particular way here. How do you get to work? Well, I have to take the bus. Well, what do you do for child care while you're at work? I don't have any. Oh, so perhaps that's why we have a neglect problem, that children are being left alone so that kids can go to school, so that they can work. But we know that what usually happens instead is that kids aren't working and they're dropping out of school because they simply can't juggle all of the responsibilities. So perhaps the best interest of the child factor would help judges think about maybe this instead of pointing the finger and judging based on youth, think of it in terms of flip it, say that youth may be a contributor to this problem that could be sort of made less onerous by some sort of support and resources that adult parents wouldn't necessarily need in that circumstance. So the idea is that the best interest factor should encourage courts and people in the legal system to be conscious of these infirmities and to encourage parents who really are not necessarily bad parents, but young and maybe not ready, right? I mean, at 16 years old, not ready, 17 years old for the responsibilities of being a parent, but that they could do a very good job if they simply had some support, perhaps some training, that would keep families together, which we know is the best, is the gold standard, if we can get that, if we can achieve that goal. So that may not be the one thing, the panacea, the one thing that solves what is potentially a problem in every state, but it's a step, I think, in the right direction of kind of sensitizing courts and people in the legal system to the issues that confront young parents. So, thank you.
Thank you very much, Professor Fershee. We are now going to take our final break of 5 minutes before the presentation by our last speaker and closing comments for the symposium. Is Mr. Andrew G. Oosterbaan. Mr. Oosterbaan has served as Chief of the U.S. Department of Justice's Child Exploitation and Obscenity Section since 2001. That's a long time. The agency uses its own, in case you hadn't noticed that, I thought I'd point that out. Well, I try to help. That agency uses its own in-house investigative unit to target online child pornography networks and uncover large-scale sexual abuse of children. And these efforts have led to hundreds of successful prosecutions nationwide. The Child Exploitation and Obscenity Section works closely with the U.S. Federal Bureau of Investigation, the FBI, and the National Center for Missing and Exploited Children. And it has helped design and implement a nationwide strategy against child prostitution. In his role as Chief of the Child Exploitation and Obscenity Section, Mr. Oosterbaan advises the leadership of the U.S. Department of Justice in policy matters pertaining to child exploitation and obscenity, and he has been centrally involved in drafting legislation on these subjects, including the Adam Walsh Child Protection and Safety Act of 2006. In recognition of his outstanding leadership, the U.S. Attorney General recently presented Mr. Oosterbaan with the prestigious John Marshall Award for Outstanding Achievement for Participation in Litigation. Mr. Oosterbaan also wrote the foreword for a book entitled Understanding and Preventing Online Sexual Exploitation of Children, which is available for purchase in the WVU Law bookstore in the law school lobby. Mr. Oosterbaan received his bachelor's degree from Valparaiso University and his law degree from the Chicago-Kent College of Law. He will be speaking today about the future of child protection.
Thank you. Let me start by saying for the record that I am neither a woman nor chocolate. So, please take note of that. No, really, I want to start by thanking Dean McConnell and the Law Review for, one, coming up with such a great topic, a topic that is obviously, because I've been doing this such a long time, is near and dear to my heart, and for the invitation. It's a real privilege to be here. Don't get a lot of opportunities to speak at law schools. That's great. It's a real privilege to be a part of this great and experienced panel. So thank you for that. And I bow to the Law Review, but let me give a shout out to my non-Law Review brothers and sisters and say that, you know who you are. I didn't go to all my classes either. In fact, I went to night school, and look at me. I run a section at the Department of Justice. There happens to be a Federal Circuit Court judge in the audience who used to work for me, although she probably doesn't admit that to anybody. Look, you're about to find out why I don't get invited to a lot of parties. I'm here to talk about child protection, but really more from the perspective of threat analysis. So you're going to hear more about what the threat is, and you'll learn about what we'll probably need to do to protect children because of this threat. It is an area of law and law enforcement where law really struggles to keep pace, because we're going to be talking about child pornography. Child pornography is something that is all about the Internet. It's trafficked on the Internet. And the law has trouble keeping pace for a whole variety of reasons, but for the biggest reason is the technology and the fast advance of technology. Let me also say that, start out by saying anyone who works in this area hates the terminology child pornography. It doesn't really fit, but more importantly, it misguides people as to what we're really talking about, and I think you'll see that through the course of this presentation. All right, so the premise. Here are the points that hopefully I will be able to establish through the course of this conversation. So there is a link between child pornography and child sexual abuse, actual physical abuse. And it goes beyond the victimization that you would see in the images themselves, depicted in the images themselves. Another point of my premise is that a dedicated interest in child pornography evidence is a desire to sexually abuse children. Now, seems obvious, but we have to state that up front. This interest evolves, and this is where we start to get a little more controversial. This interest evolves and can intensify and can lead to offline defending. Online socialization, the fact that individuals meet each other online, has an impact. That this socialization, when it's centered on child sexual abuse, can, again, increase the risk of offline offending. And finally, as the population of socially networked pedophiles grows, so grows the risk to children. So that's the premise. The conclusion then would be that this is something we really have to worry about, that this is one of those areas of child protection, protecting children, that we have to pay serious attention to. This combination of socialization of child sexual abusers, the burgeoning market for child pornography, and this technology that keeps advancing to help them do what they do. Now, this is what I'm saying, what I'm talking about, is the subject of great debate in the legal community. Judges, in particular, have been very vocal, in the federal system anyway, about not necessarily accepting that these are dangerous individuals at all. So we'll talk about it, and then you can come up with your own conclusion, but hopefully my conclusion will be supported by what we talk about. All right, so the other thing you have to realize is I am part of law enforcement. So where are the future prosecutors in the group? None. At least I have somebody. Anyway, you have to recognize anyone who's giving you a conversation like this is going to talk about issues like this, where they come from. And this is where I come from. But law enforcement sees this problem in ways that others don't for a lot of reasons, one of which is because we're allowed to and do get inside these computers and find these places on the Internet that this activity is going on, and we see things that other people don't see. We see people like this. We see people who, and I don't know if you can see it because the lighting's a little funny, but this is a grown man, very bizarre-looking man, dressed in a little girl's bathing suit. He's surrounded by Christmas things and toys and Winnie the Pooh and so forth. No Pigpen. And he might seem, safe enough unless you realize that he was posting this online, which, if you can read it, says, and he says, this is no joke, he's offering $50,000 to rent a child. And he describes what he wants this child to be willing to do. And you might be look at this and say, well, this is just one individual, he's crazy, and we don't really have to worry about the individuals like this out here, because what kind of impact can they really have? Well, the reason why he's posting this is because he knows there are a lot of people who can satisfy this claim, this request, and would. This is the other kind of thing that we see online. This is a survey that was posted in one of the forums, one of the groups that we were investigating. Have you thought about whether or not you would abduct a preteen child or girl? About 42% of the responders said, I thought about it, and if circumstances were right, I'd do it. This is an individual in one of these, different individual in one of these groups who posted the sonogram from his wife and so was telling his cohorts in the group, I've got a new baby about ready to be added to the game. And then they have a conversation, they all do, about what they will do to this baby once this baby's born. So, this is the kind of thing we see that not everybody sees. This is one of the reasons why this is a tough area to understand, but it's critically important to understand it if we're really going to respond to the threat that at least I think exists. So what about child pornography? What's the role? What is the concern all about? So the Supreme Court, quite a while ago, almost as long as I've been part of the child exploitation section, told us what was at the heart of child pornography. And they were focused on the images and the harm to the children depicted in the images, the reputational harm, the ongoing reputational harm that exists. And this was something that's very, very true and very, very valuable, but it just doesn't go far enough. Because the threat that we're going to talk about is much more than just what's depicted in these images. It goes beyond, the molestation that was depicted. Child pornography has always been a tool for abusers. In other words, it's something that abusers have used. If they can show a child child pornography, they can show that child what they want that child to do. They can say this is acceptable, this is how you do it, and it's also been long used as blackmail. So abuse the child, take a picture of the abuse, threaten to expose that picture if they tell anybody about it. But more important than any of that, so we need to start to get into what's the bigger concern. And the bigger concern is, what is child pornography all about to the person who is collecting it and using it? And this is where we need to talk, we need to get into some of the research that's been done by the true experts, the people who really know what they're talking about. And it may seem somewhat obvious, but the child pornography, the use and collection of child pornography becomes entwined with the actual abuse or a compulsion to molest children, right? It's something that the more and more they're exposed to it, the more entwined they become with this compulsion to molest. And the case studies that's up on the screen right now, they were talking to individuals who were involved in child pornography, and they were saying, look, it intensifies my desire. It gets me more aroused the more I use it. Again, this is something we need to pay attention to. This idea that the use of child pornography, what we're talking about is masturbation and using child pornography in that fashion to satisfy your sexual desire, or these pedophile sexual desire, actually fuels the desire to molest a child in ways that you might imagine. This idea that it becomes never enough just to look at the images. Actually, in this slide, the individual said it's like a drug. The more I used it, the more I wanted to do the actual molestation. And it can, at some point, with some individuals, drive thought to action. So this individual who's mentioned on this slide was saying, look, I started just using child pornography, collecting child pornography, but at some point it got me thinking I wanted to molest children. And we're going to talk about some of the reasons why that happens, and that's what finally got me to abuse my own daughter. Never thought about that before, but at some point it brought him to that action. Other ways to establish the link are to actually talk about individuals who have been arrested and incarcerated just for child pornography offenses and ask them, have you molested children before? Get it from them. And this is a study that was done in the U.S. Bureau of Prisons, initially done many years ago, updated fairly recently in, I think, 2009. And so they had 155 subjects. 85% of them admitted that they had molested a child without detection. 85% of these offenders, 131 out of 155 subjects said, admitted that they had molested children without detection, and that they had an average of 13.5 child sex victims each. 74% of them had no documented contact offenses at sentencing on child pornography offenses. We would never have known that. And even of the 24 subjects denying contact offenses, denying that they had molested a child, 9 were polygraphed and only 2 passed. This is another study. This was done by a Canadian researcher, and he basically took all the studies that have been done, and he was and did what's called a meta-analysis to show the proportion of individuals caught for online sex offenses that have a history of contact sexual offenses. Now, the outlier that they're talking about here is the study that I just mentioned from the Bureau of Prisons. The reason why they call it an outlier is because the percentage, that 85% number, is so high, it was out of line with other studies. So without that, even without that, all the studies taken together, 45% have, child pornography offenders have a history of molesting children. With that study, 64%. The symposium that's up on the screen now is a symposium that I put together. The Department of Justice funded it. We used the G8 as kind of a vehicle for it because we wanted to bring experts from around the world. All the people who have done research, who have researched into the offenses and the offenders and victims and the victimization and surrounding child pornography from all the countries of the world. So all the G8 countries were represented, and we brought all the rest of the experts in from everywhere. There were 40-some experts there. And the whole idea was, let's talk about your research and see if we can come up with points of consensus. What do we know? What do you, the experts, agree? And the idea for me was I wanted that consensus so that I can go to policymakers and say, look, the experts of the world agree on this, and we need to do something about it. And, of course, as you see on the screen here, these are the points that I'm raising to you. This fact that the link between child pornography and contact offenses against children is clear. They all agree. You might not understand every aspect of it, but the link is there, and it's clear. The Internet and other technologies have created a global forum fueling the production. Production of child pornography means the abuse of children in front of a camera, in front of a video camera, and the rapid dissemination of the new materials depicting the exploitation and sexual abuse of children. Internet facilitates this, and the greater availability of child pornography exploitation, child sexual exploitation materials has stimulated the demand and production of even more extreme, sadistic, and violent images of children and infants, and we're going to talk about that too. Now, part of the reason why this is important is because of the statistics that are on the screen now. These come from the National Center for Missing and Exploited Children, and they get these numbers from the images themselves. When they have identified a victim in an image, they can find out about that child's abuse, and more importantly, they can find out who abused the child. And this is no surprise, but if you look at this pie chart, the vast majority of child molestations were committed by parent, guardian, other relative, neighbor, family, friend, babysitter, coach, guardian's partner. Again, no surprise. Why? Because these are people, all of them, are in a position of trust with respect to this child, right? Anyone who does this work knows that's the risk to a child. You know, one of the policy perspectives that I have to continually promote in the Department of Justice and other places is this idea that, look, what we hear all the time about, what I get all the time about, is parents who are concerned about their children who are online. I have, a freshman at the University of Florida, and for years, when I would give presentations like this, I'd be, you have a teenage boy. What do you do? And I would say, really, I don't do much of anything other than educate, right? And the reason is because the real risk, I'm not saying there aren't people on the Internet trying to find young children, young teenagers, and molest them. That certainly is the case. But if you look at the bigger threat to a child from molestation is for the people he or she knows. That's a fairly large circle, right? Now, if I'm right about child pornography and the influence it's having, this dynamic that we're talking about, the fact that maybe it's a growing problem, and if this circle around children is a circle of trust, within that circle of people are on that continuum, they're using child pornography now on their continuum, you'll never know. But your child is at risk from that person. So, there has been a period of escalation. We talked about, Ferber, and we talked about how things kind of, from the Supreme Court's perspective, can start there, and how they described and how they dealt with child pornography. But how have things changed since then? And have they changed in meaningful ways? And I'm here to tell you that they have. As has been pointed out, and as I've reiterated now several times, I've been doing this a while. I didn't always do this work. I was a prosecutor at the U.S. Attorney's Office in Miami for 10 years, and didn't do a lot of this work. In fact, I can tell you back then, the offenses were a heck of a lot different. What we saw then was a heck of a lot different than what we see now, right? And much of this change is symptomatic of the internet revolution and everything that the older folks in the audience know a lot about, and younger folks just kind of take for granted. They would never call it a revolution. It's just life to the young folks in the audience. But the offenses and the offenders in particular have undergone a change over the course of time. It's kind of dramatic, and it's certainly worthy of serious consideration. And it kind of starts with this concept that you have to keep in mind. Again, especially the young people in the audience, which is most of the audience. Before the internet, what it meant to be a pedophile was a lot different than what it is today. Why? Because you were, in your mind, completely alone. It's not like you didn't realize that there must be other people like you out there somewhere, but you really had no way to know that. And certainly, you knew that you were condemned by society. You knew you were wrong in many, many ways, in many important, serious ways. But you never had any way to know that there were others like you out there, other than at these CD bookstores that sold adult material. Occasionally you could find child pornography, right? And if you knew about that and you saw that, you figured, well, if there are people publishing this material, then there must be others like this out there. Problem is, the images, as we'll talk about, were a heck of a lot different than they are now, too. But when the internet develops, it's almost like overnight they were introduced to this massive community of self-interest. And that was a mind-bending time, a revolutionary time in their mind for them, when they could overnight almost realize how many others like them there were. So what happens when you find out, when you connect with others with this same offensive and criminal interest? Well, you can imagine. It bonds these individuals together, but more importantly, it normalizes this. The human mind's an amazing thing. You can very easily convince yourself that you're normal. We all want to be normal, If I'm collecting, Hummels, little statuettes, and I'm spending thousands and thousands of dollars on this, I can convince myself in many, many ways that what, I'm doing is normal and okay. It's no different here. And what happens when they communicate is not that they don't just communicate about the weather, right? They're communicating about the abuse of children. And this can provide highly persuasive encouragement to these individuals that they're only getting when they go online, right? And they, what this slide tells you is that what can happen, or the kind of communication could get really, really ugly. But it's real. I'm here to tell you it's real. This is not just puffing. This is real stuff, because it happens all the time. I mean, it actually happens all the time. And this idea that they all want to validate what they're doing. They want to find that acceptance, which they get when they get online. This guy, down here at the quote at the bottom, I had friends all over the world. I never had so many friends before. We were the elite. I'll guarantee you this guy was living in his basement. I'll guarantee you he had nothing in his regular life, but he found a real life. He found a real connection online. And you can imagine what that does to individuals. And the thing about child pornography is it is how they recognize one to the other that they're the real deal. This is how they understand that you're not just talking. You're the real deal. It's a commodity. Yes, it memorializes the abuse, but it's a commodity for them, and like any other commodity, the same stuff is not good enough. It's not worth a lot if it's the same stuff. If they keep trading the same stuff, it's not worth a lot. The same Pokemon card, if every kid had it, would be worthless to that kid. It's the same thing here, right? It's valuable currency. But it is the thing that bonds them. So it gratifies, stimulates their sexual desire, but it also validates them as a community. It's incredibly important to that community. And of course, as you can imagine, if it's that important to the community, it is how they build status. So the basement dweller, the guy who's living in his basement, as I'm saying, this is how he's going to gain status. This is how he's going to feel better about himself. He's going to feel better because he has something that everybody wants. And that something's going to be an image of child pornography that he produced because no one else has it. So, as a quote here at the bottom, I managed to find something no one else had. He's talking about the people who run the forum. They were really happy. It's like an art collector who found a lost Picasso. And it is highly focused on the production of child pornography. It is more than you can really even imagine. These forums are all about producers. They have, we'll talk more about this as we go through, but they have a hierarchy. The people at the top of the hierarchy are producing images, but not just their own child pornography, meaning molesting children and taking video and pictures of it, but they're doing something that nobody else is doing. Those are the people who are elevated in that society. So there's an incentive to create these kinds of images, these more, more problematic, more extreme images. So we've seen evidence of this in a lot of different places, right? And what I've tried to do is I've tried to, in a lot of these slides, I'm trying to cite from cases that are out there. And you law review people better not be checking my cite forms, because I'll tell you right now they're not right. But we've known from the earlier days, what the images were like through some of the cases that were done. And and I've got some descriptions from actual cases that are out there: naked children on beach. Beauty pageants, stuff like that. Well, fast forward a little bit, and there's some graphic language in here, and so if you don't like it, don't read it, but this is coming from actual cases, so it's out there. It's really, really horrible. Not that many years later, but what happened in between 82 and 2008? Internet. And this is what we've got now all of a sudden, horribly violent, torturous abuse of younger and younger children. And the younger children part of it is something that we can't forget, because there was a time when the only child pornography, again, when I first started doing this in the ancient times, the children, the hardest thing we had to do back then was prove that they were actually children. In other words, that they were under 18. Now that's not a problem at all. These are statistics coming from the images that the National Center of Missing and Exploited Children have. 52 to 55% appear to be prepubescent. Yes, that's what prosecutors will tell you they're seeing, and agents. It's babies and toddlers, more than anything else. So the internet, great facilitator. It's a great facilitator for everything. We know that, right? Our lives now completely are kind of run by that great facilitator. But this great facilitator that the internet is greatly responsible for where we're at right now in this problem that I've been describing, video technology. Imagine when it went from images, still images, pictures of this abuse, picture of the worst day of a child's life, to a video of that event where one can watch it happen, bit by bit, and more importantly, can hear it happen, which means they can hear the child and they can hear the child's reaction to this molestation. And when you read these descriptions, like I'm here in the doctor's appointment, what is what's happening in the minds. And frankly, this is a complex psychological mindset. They don't all fit into one category. That's not every person who has a sexual interest in children is a pedophile, because it's a certain formal distinction that Dr. Gold knows, I'm sure, much better than I do. But more importantly, not every person who wants to have sex with a child also wants to hurt that child. Some of them feel like this is something the child, they either convince themselves or they are so deeply disturbed that they actually believe the child is somehow benefited, somehow enjoys this. There's different classifications associated with it. But you can tell that that there's a certain portion of this population that is very much about the physical, violent abuse of a child sexually. We know I put Operation Achilles up there because more and more of our operations now involve videos over images, and this was one of the earlier ones, where this group had over 400,000 images just in this one group. We convicted 14 people here in the United States, but there were people all over the world that were ultimately convicted, many of whom were actively abusing children, and the videos were a big part of that group. Now, this idea of streaming video, too, has revolutionized it. Because why? Because these groups and forums are abusing children live online for the benefit of the whole group. So they get to watch it. They get to watch it happen. That's changed things immensely. Plus, in places like the Philippines, they're streaming videos. They're charging people in the United States. It's kind of a famous case now where a bunch of soldiers in Iraq were in a tent around their laptops, all watching the abuse of a child in the Philippines, and they had all paid money to watch this happen. So, again, technology is really changing this offense. And of course, this streaming video, the webcams and all this have changed the threat dynamic, because what we're seeing now is these guys are getting really good about convincing. There are a lot of vulnerable young teenagers out there who have webcams on their laptops and on their computers, and they have found ways to convince. In other words, they're good at getting into teen forums and things like this, and pretending to be teens and so forth, and then somehow convincing teenagers within that forum to take pictures of themselves in compromising situations, and then blackmailing. This has actually become very common, blackmailing the young girl, it's usually a young girl, to continually produce images, because they also, within that group, have found ways to get the contact information from all their friends. So in other words, emails and so forth. They can easily blackmail them and say, look, I'm going to send this to all your friends unless you keep giving me the kind of images that I want from you. Again, becoming very common. Or more common than you'd think. So, what about, we talked about how the offenses themselves, the images and so forth, have gotten worse and got more egregious. How about the population of offenders? Is that growing? And that's a harder thing to develop through hard statistics, as you might imagine. But there are a few things that we can kind of point to that evidence that the population is probably growing. This idea that the internet has socialized this group of child sexually interested children, offenders, is certainly one thing. But even early on in after the internet was developed and these offenders started to find each other online, there still had to be a place for individuals who didn't know how to find other individuals online when they were looking for child pornography. And very quickly, commercial websites offering child pornography developed, and there were many, and there still are, although it's not as big a thing as it once was. And basically what these commercial websites allowed was people could actually go and pop down their credit card number, and they'd have access, just like any other pornography website, to as much child pornography they wanted on a monthly basis, and that's what they would do. This was actually one of the reasons why this is not as popular anymore, is because this was an easy thing for us to investigate. We could get to servers where these customers, lists were held, and we'd have information about every customer on there. And one of the early cases that we did, this was, probably 2003, around 2003. The website operators, the people who were responsible for the content, were in Belarus, but the credit card aggregators were in the United States. So we prosecuted the aggregators and then worked our way up to the operators. But more importantly, in the very first wave, when we put that case together and took the servers down, the customer servers, the customer database, the very first wave we sent out were 10,000 leads to the United States. And this is, again, back in roughly 2002, 2003. That meant in the United States alone, there were at least 10,000 customers that we could connect to. The other way we can kind of look at this by numbers is through the reports to the cyber tip line at the National Center for Missing and Exploited Children. Now, the cyber tip line sounds like it's a place, they call themselves the 911 for the internet, and it's true, they are. But the vast majority of these reports are not coming from individuals. They're coming from ISPs. They're coming from Microsoft. They're coming from Facebook. This is when the law provides that if the company, the electronic service provider, finds child pornography, if they're aware of it, they don't have to look for it, but if they're aware of it, they have to report it to the National Center for Missing and Exploited Children. So the vast majority of statistics are coming from reports from internet service providers, people who are electronic service providers. And you can see how that's grown over the years and what the kind of number is now for that per year. So, in the end, put it all together, this is where we're at, where, kind of the conclusion to this. Sharp increase in the severity and depravity of the child pornography offenses, okay? These technological advances that we're talking about are just making it easier for these individuals to do what they do safely, meaning, without being detected, or at least without being found. And keep in mind in that regard something we'll talk more about in just a minute. Especially you young folks know that, you're online. You're never online or almost never online with your real name, right? I mean, there's always some kind of moniker on there that that other people don't know. Well, that's the way it is for these guys, too. They're not using their real names to do these kind of things. So the ability for law enforcement to address this crime entirely depends on our ability to take what we see online and resolve it back to the individual who's responsible for doing whatever it is we saw, right? And that has everything in the world to do with an IP address, which is how that event resolves back to a provider who we can go to and say, okay, tell me who that is. Okay, that's how we've always made these cases. And that's becoming really very difficult to do. Every day it gets harder and harder to do, and we'll talk just briefly about that. And this idea that there's an expanding proliferation of safe havens, okay? This idea that there are places they can go where it's all about anonymity, in other words, preserving anonymity, and the fact that they're gathering together, these individuals, in those areas. And all of this is reflected in changes in the content of the images, for the reasons I think I've mentioned, and the fact that there are younger and younger children being abused. Okay. So what does this escalation and evolution mean for the future of child protection? Not really. So if you've been listening at all, you know that I believe that there is, there's been a change of these offenses and an evolution in terms of the offenses and an evolution in terms of the offender. And it's important to realize that like everything else that you can think about, offenders, they don't stay the same. So maybe they did start initially by finding a commercial website. But if they are really interested in child pornography, if they're really interested in the abuse of children, they don't just stay static. They evolve. And so, we've kind of come up with this Child Pornography Offender 2.0 moniker because that tends to, put these guys kind of where they are because it's all about the Internet. And, we always have to keep in mind that the individuals we come across likely have been doing this a long time now. The Internet's been around a long time, so if they're, if they're of a certain age and they've been using the Internet to commit these offenses for a long time, they're farther along that evolutionary scale. And they are not satisfied with the same old material. They move towards a different material. That they never stay isolated because, again, if you've accepted anything I've said, you realize the importance to them of having a community and having people that are like them and that can make them feel normal and make them feel like that what they're doing is acceptable. That maybe there's part of the population that doesn't understand it, but they just don't understand it. It's normal. That's incredibly important to them. And that they're, that they tend to find that people are kind of at the same point in the evolutionary scale. And that they're more dangerous because their offense mindset is deeper. They're farther along the evolutionary scale, and they're with people who are abusing children or about to abuse children. So, one other graphic representation of this is gaining more and more acceptance is this pyramid. This is a pyramid of evolution in a sense. You're evolving towards the top of the pyramid. But it's also, one of the ways that we kind of look at the level of seriousness attributed with an offender. So if you're at the base tier, you're less serious than someone at the second tier and, of course, the third tier. So it's both things. It's a way of understanding how an individual evolves through this, offense conduct and maybe how, we look at the seriousness of the offenses. So the tier 1, this is really a singular experience, kind of that commercial website thing I'm talking about. They're not talking to anyone else, they're not communicating with anyone else, they're getting their images, they're using their images. Peer-to-peer software has been a big part of law enforcement's approach for quite a while now, because it's a real easy thing to investigate for a variety of reasons we don't need to get into. But what we're finding there, and the federal system has been really inundated with these cases, which is one of the reasons why the judges are saying why I don't see this as maybe necessarily that serious offense, is because they're seeing mostly these peer-to-peer offenders. You know, we don't have the time to get into it, but there's a variety of reasons why a lot of prosecutors haven't brought some of these other cases that I've been talking about. Tier 2, now they're getting into more of a one-on-one experience with somebody else, email, instant messaging. This is something that they've started to branch out, started to find other people, and eventually you get into this tier 3. And this is where this social dynamic, what I'm saying is a dangerous social dynamic, really comes into play, right? Because if they didn't have this social dynamic, you probably wouldn't see much of that evolution I'm talking about here, because there wouldn't be that normalization and encouragement and acceptance, and this idea that social rank is based on production, and of course the powerful stimulus that this actual abuse or this desire to actually abuse children really is. And I liken it to terrorism investigations, because we've seen that especially with respect to homegrown terrorists. This idea that they probably would stay there in their basements, they would be pissed at the world, and they'd be bitter and so forth and so on, and their thought process would stay within their head. But you introduce them to other individuals who want to encourage them to do something else, and their thought process starts to change. This is what explains the willingness of someone to go and blow themselves up. It's not too different in this context, at least in my opinion. And the group characteristics we see are pretty similar, and that is telling, I think, too. From group to group, to forum, social network to social network, they seem to have the same kind of characteristics, right? They're very organized. They really feel this special sense of community. They're special. They record their history. They're very dedicated to it. They're on it all the time. There's a lot of social deviance, and this bonding and social rank based on abusing children shows a certain element of dangerousness, because when we investigate them, there's always a lot of them abusing children, and sometimes sharing their victims with one another. So, one of the characteristics that is absolutely commonplace is this idea that it's a community of rules. This is important because they do realize they're committing crimes, and they have to keep safe. But it also is about understanding what this forum is all about. Now, this is one of the more tame forums because it's focused on older children, but this is pretty much similar to what we see here. Look, this is what we're all about. If you're not about this, go somewhere else, but this is what we're about, and here's how we're going to operate and keep each other safe. This hierarchy that I mentioned, it's important. Why is it important? Because, as I said, hierarchy is based on where you're at. Kind of the worse you are in our minds, the higher you would be in their hierarchy. So, the hierarchy is generally based on if you're just collecting and distributing, you're down here. But if you've produced, you're here. And if you're someone who's producing really, out there material, in other words, doing horrible things to kids that no one else thought about, now you're at the top. And this is something that I think speaks to that. This idea that exclusive content meaning the content of the image or the video, and it's these are their own words. Look, let's be straight about this. I want you. I can't believe you don't understand what super hardcore means. But if you don't, let me tell you what super hardcore means. Very young kids getting acts and preteens in distress and crying, getting hit hard with a belt and so on. They want it to be very clear. You are not getting in that tier unless you are providing this kind of material. And the other characteristic, of course, is that it's always international. And every one of these forums that we break into, they're all over the world. This is one from 2008, 550 members from 50 different countries. Makes it really hard to investigate these things. It really does. And again, we don't have the time, but consider the legal process when the servers are in France. How do I get that? And how long is it going to take me to get that? that information. And I can't do anything until I get that information, and some of these countries won't give it to me. So it can get really, really difficult to do. And, by the way, we're investigating, and all along we can see what's happening to these little girls and these little boys, right? I've had an investigator tell me, you know, it was something he's really never gotten over is the Achilles case that I mentioned earlier. He's an Australian investigator, and he was seeing the abuse as it happened because they knew all the images, and when a new one popped up, they knew, you know, that girl just got abused. And then another video would show up with new abuse that she just underwent that abuse. And this guy said, I watched her grow up through the videos and images that I was seeing online, and I couldn't do anything about it. It was like, you know, we're moving on in this investigation, you know, like a ship, you know, moving off onto the horizon, and she's back in this little boat, and we're leaving her behind. And it was a horrible thing for him to go through. But that's what you're kind of left with in these things, because that little girl wasn't in Australia. She was in the United States, and, you know, he was having a hard time putting everything together. So, the impact. How much time do I have now? Okay, 5 minutes. All right. The impact of technology and what we're doing. Yeah, I do think that to some extent this is how we refer to it at the Department of Justice, is that the Internet is going dark. And basically what that means, and this is where the storm clouds reference comes from, what it means is it's really getting enormously difficult for law enforcement to continue to investigate these individuals who are probably the most dangerous individuals in our realm that we deal with. All the things that we now are taking for granted in technology are things that make it more difficult. So this idea of online storage in the cloud, very cheap. It's what enables us to access everything off of a smartphone. The fact that everything's out there in the cloud. It's not on our server. It's not on our phone. It's somewhere else, but I can pull it down anytime I need it. Well, you can imagine that can be very helpful to the individuals who are doing this kind of thing, especially when you consider that many of these cloud configurations make it inaccessible to us. When we serve process on one of these ESPs for content that we know is in the cloud, they come back to us and say, well, it isn't, they give it to us in a format that we can't read. It's indecipherable to us. Or it's inaccessible in a sense that it doesn't resolve back to an individual. They can't tell me who it was that put it there. This idea that encryption now is commonplace. Encryption, something developed in the Cold War kind of mentality from countries who had to protect their data, and they made these encryption processes again impenetrable. You have to have the password. I literally cannot go to the U.S. government. I can't go to the CIA and tell me and have them tell me how to break that code. It's classified. So unless I have the password, or I've come up with another method of getting this stuff before they encrypt it, or before it becomes encrypted, I'm not going to get it. And so, and there's no legal recourse. There's no way I can compel under our law somebody to give up their password. Unfortunately, they consider that to be a problem. And so we're left with other kinds of techniques. And sometimes what that means is that we're going up on Title IIIs, which are wiretaps, so that we can maybe put a keylogger on there so we can, get when they type their password in, and so now I know what their password is. That's one way. Other ways is that, we try to execute a search warrant when they're online so that, that it's not encrypted at that moment, and I get in there before they encrypt it. And the other way is that, somehow we got to get them to cooperate and give us the password, which is, as you can imagine, not easy to do. So lots and lots of new tools to hide your identity online. Proxy servers have been around for a while. This idea that that there is ESPs provide access through proxy servers, which move your communications from one to the other in ways that eventually block the identification of the individual. But more importantly, we now have entire networks that are anonymous. The Onion router is the big one, Tor. But Freenet has been around, and this is thanks to your U.S. government, because the U.S. government created Tor, the Onion network, and they're completely anonymous. What we're finding, and this is where the law comes in, and this is where the new generation of lawyers are really going to have to deal with this problem. the law is antiquated when it comes to the internet. And we now have a situation where the only way we're going to be able to find individuals on tour is, in a sense, it's kind of like hacking, which of course the government's not supposed to do. There's lots of important constitutional reasons why we can't do some of these things. And yet when I go to a judge and try to explain all this to them and ask for warrants and things like this, they don't quite understand it. So this is a tough thing. And I should say that one of the byproducts of this is that, of course, offenders feel that they're completely anonymous, so it emboldens them. They get more aggressive, and we see that all the time. Mobile platforms, as you can imagine, these iPhones and smartphones and so forth, I mean, they're really perfect for these offenders, but more importantly, this is what our kids are using. This is what teenagers are using. So it makes them more vulnerable to the kind of things that we talked about before. And of course, the bad guys are even better at it than the teens are, and they're very used to exploiting the vulnerabilities of children to use them. And the fact that we have become such a socially networked society, and that our children are used to social networks, the fact that for children, for teenagers, and so forth, they're very used to. My son, this idea that, hey, I mean, he gets the fact that there's false personas online. That's just it. The kids are used to that kind of thing. They're used to casual acquaintances online. He's got a gazillion friends on his Facebook page. He doesn't know most of them. They're used to that. But of course, even better at that are the bad guys. And we've got lots of examples where Stick'em, YouTube, Skype, and other platforms like that have been used to blackmail children. So what's the good news? I don't have any good news. Unfortunately, this is going to be a challenge, and all I can do is challenge all of you or ask all of you to kind of know that the next generation of lawyers is going to have to deal with the legal issues that I've mentioned. You're going to have to recognize what the Internet's doing. That doesn't mean the Internet's bad and should go away. We should turn it off. It doesn't mean that at all. But we have to be smarter about the way we deal with it. So that's it. Thanks.
Thank you very, very much. I think that everyone here today can agree that our symposium has been superb. It is a compelling, an important, and sometimes a disturbing subject, and our speakers have helped shed light on it from a variety of perspectives, local and national, medical and legal, civil and criminal, preventive and enforcement, executive and judicial. And I know that the editors of the Law Review had hoped to achieve, and the entire Law Review had hoped to achieve that sort of diversity of perspectives. I think they have accomplished that goal superbly, and we have our brilliant panel of speakers to thank for that. So on behalf of everyone at the WVU College of Law, we're all very glad that you could be here today, and we thank you very much for being here. At this time, I would like to call the Editor-in-Chief of the Law Review, Amber Moore, up to the podium.
Thank you all very much for coming today, and thank all of you for taking your time to be here and to talk to us. We've certainly learned a lot. And to show our appreciation, we have a small gift for each of you. These are a little touch of West Virginia. They were purchased at a small locally owned cafe just down the street and were made by West Virginians. And we also have one for you, Professor Bowman, to show our gratitude for taking your time to facilitate today. So again, thank you very much. We appreciate you, and safe travels. Professor Bowman?
Well, thank you, Amber. So our time grows short. We do not have a long time for questions, but what I would like to do to close out the symposium is to give each of our speakers 2 minutes for your preference for closing comments, if you wish. If not, that's fine. Or you may add to or clarify something that you said, or if you would like to respond to the remarks of someone else on the panel. And why don't we start with our first speaker, Dr. Gold. Do you have anything you'd like to say in conclusion?
Sure. I think ideally I would have come to the conference and then done my talk, because I think that as a non-law professional, I've learned a tremendous amount in my conversations exactly about how the law works and the kinds of things you see that would have informed some things that I would have liked to add and certainly would learn more about. We think that one thing that I didn't include is how much contemporary research and knowledge there is about brain development. And I think that if next time, if there, have an opportunity to speak with lawyers, I think that obviously there's a need for an infusion of the hardcore science about early brain development. But it's been a fascinating experience. I've learned a tremendous amount from all of you, and thank you all for having me.
Judge?
There was one thing I wanted to mention when you look at these child abuse and neglect rates. The root of much of those are poverty, and until we learn to attack economic issues and poverty issues, I'm afraid this is going to be with us. And to the young law students, I want to say that when you go back to wherever you practice, this is a very rewarding area of the law. And in most counties, the judges are begging for people to be guardian ad litem and to represent parents and practice in this area. So I hope you'll take the child protection class here at the law school, and when you go back out to your counties, that you will go see your judge and say, I'd like to get involved in this area of the law. I think it's, although frustrating, it's the most rewarding work that you will do.
Thank you. Ms. Hale.
Yes, I wanted to just say last that the most important thing about this data book, it's the first time that we've been able to tell the public about the condition of children in a way that's understandable. And what we're trying to do is educate the public about the needs of children in the hopes that action will be taken. I have a few extras, and you can clamber up here. And thank you very much.
Travis will hand them out for you.
What?
Travis, I said he'll hand them out for you.
Professor?
Well, I've been struck as we've been sitting and listening to what our kind of diverse topics have covered. First, how much they overlap, but secondly, how important this idea of child protection is, because one of the reasons that we have all of the problems that we've discussed today is because the people who are abusing or the people who are getting pregnant at a young age were likely brought up in an environment where they were victims of some sort of abuse themselves, which creates a cycle, and they become abusers. Young girls who get pregnant are probably statistically are often the children of young parents, and abusers were often abused themselves. So child protection is how we solve these problems. If we stop the abuse at a young age, then we may be creating fewer abusers. So it's in one sense it's frustrating because of the cycle, but in another it's a very compelling argument for trying to intervene and protect kids as best we can, as early as possible.
Thank you. Mr. Oosterbaan?
I actually have a question for Dean McConnell. What are you doing wrong that you have so few future prosecutors in this case? It's really disturbing. Maybe I should blame Judge Thacker, because I understand that she's teaching child ed here, and she's obviously not doing a very good job if we have one future prosecutor in this group.
Well, I think it's wonderful you're here because you've been inspirational.
Oh, they don't want to do that.
They'll begin to think about it in a different way.
And now we know why she's the dean. Because that was an excellent response. A+. If I can ask one question, and using my prerogative as moderator, for any of you, what is something that you've learned here today? How might you approach what you do in the area of child protection differently based on something that has been said and discussed here today at the symposium? Anyone?
I've listened to Dr. Gold. Always try to never quit learning and And I know that child development is a big issue with when you decide these types of cases, but I'm going to go get her book and read it. So, I think I can learn a lot from it.
One of the things that I learned, we're going to do a data book on teen pregnancy, and it's not that we're experts, but we'll have an infographic, and the thing is preventing teen pregnancy. And you sort of opened my eyes to the fact that we ought to be talking about what do we do to support those teens who are pregnant. And the place that you were talking about is very hopeful. Largely, when I see a pregnant teen, I say, that's the end. She's going to be poor. The kid's not going to do very well. But there's hope.
I was going to say one more thing. I was looking at my county in this book, and I see that only 44% of the children who are eligible for Head Start go to Head Start. And so I'm going to find out why when I go back.
I think that I certainly learned about the legal limitations of adolescence, which I've never really thought about before. Certainly they have a lot of going against them in many other ways, but it just points to me that this is an important collaboration. We all have a lot to teach each other.
Anyone else?
I mean, I think I learned a heck of a lot from all of the presenters. From Ms. Hale and Judge Johnson, I'm reminded of how thankful we all should be for the people who do what they do. It's really gratifying to see people in those positions, both Judge Johnson and Ms. Hale, who can speak of a really desperate problem and with positive optimism and a smile on their face. And so it's gratifying. It's easier to do the work that I do when I know people like that are out there. And in terms of the other presentations, I think what I take away is that when we talk about childism and when we talk about how teen mothers are treated and so forth, that we're a civilized society that's not always very civilized, and that we also have a lot of work to do under the law. Which is why I keep looking out at all those bright young faces, because I'm obviously too old to make that kind of a difference at this point in my life.
Okay. I would like to end the symposium on something that Judge Johnson just said, which is never quit learning. And that's something that we should all strive to do. I strive to do that. I'm learning all the time. We should all strive to do that, and that really is what the WVU College of Law is all about. We teach, but we also learn. Now, please remember, here at the end of the symposium, there's a reception in the lobby, right out those doors, immediately following the symposium. The speakers will be there if you have questions for them or simply want to thank them for being here today. I'm sure they would appreciate a thank you in person. And also, please remember Dr. Gold's book signing, which will also be taking place in the law school lobby immediately following the symposium. So, thank you all for attending, and that concludes the symposium.